And then get the meeting started. Okay, I'm going to call the meeting to order. So good morning, everyone. Welcome to Fort Washakie for the Select Committee on Tribal Relations on this absolutely beautiful fall day, late fall day here in Wyoming. Great, probably one of the last, but we made it. So welcome, good to see everybody. We'll start out, we'll do a roll call, and then what I'd like with this relatively small group is just for everybody to introduce yourself, and then we'll get started. So go ahead, please.
Senator Barlow. Senator Case.
Present by phone.
Representative Chestic.
Here.
Representative Penn.
Here.
Chairwoman Ellis. Chairwoman Oakley.
Here.
Madam Chair, you have a floor.
Present by phone.
Thank you, Senator Case. Okay, so with that, I don't care what order we go in, but if everybody will just stand up and say your name and see who you're with, we can all come together if we don't already. You all and welcome. I do have just a little piece of business for everybody. And that is, we have been instructed, we have meeting, we have meetings scheduled for this afternoon, including like buses and times to be picked up. So we have to stay on schedule. So my thought is to move the 10:45 we have scheduled the U.S. congressional update. There's a wonderful video that came out of Representative Harriet Hageman's office, and we certainly want to get to that. But we are thinking that since that's a video, that's something that could be moved, and we certainly have to get to the ICWA issue because there's specific legislation proposed, so that we go ahead and get that started. And then we can either do that congressional update after that, or we could do that tomorrow. Is there anybody from Representative Hageman's office that is here for the 10:45? Okay, so just so everybody knows, we'll go ahead and do that. So we'll start out. We've got the intertribal developments and efforts. And so we've invited different tribal leaders. If anybody would like to come up and make that. Is there somebody from the Eastern Shoshone Business Council that would like to give us a development or update? This I guess the mic coming in and out on me, or is that just okay? See if that works better. Northern Arapahoe Business Council or a representative that would like to tell us about development or efforts. Mr. Wendland with the governor's office, is there something that you would like to go ahead?
Sorry. Good morning, Chairman Oakley. Thanks for letting us come up as a group. We finally are fully staffed. So I just wanted to quick introduce again. I'm Kit Wentland, Tribal Relations Policy Advisor and Special Counsel for Governor Gordon. To my left, we have James Sorrells, Eastern Shoshone Tribal Liaison, Anita Roman, Northern Arapahoe Tribal Liaison to my right. And we can go forward. We've got a little list here of updates, but of course, if there's any questions or anything to start off with. Well, first I'll turn over the mic to Mr. Sorrells, just so he can tell us a little bit about who he is. This is his second day, so it's a trial by fire.
Yeah, don't be nervous. Easier said than done, but go ahead and
Good morning, Zant Bechu, Chairman Ellis, Chairman Oakley, distinguished staff. It's good to be here. Prior to becoming the tribal liaison, I served 7 years with the Eastern Shoshone Gaming Agency as commissioner chairman. And that just regulates the Shoshone Rose Casino. So it was it's always a busy job. So again, this is actually I'd say my second day, but I don't think yesterday has moved yet. So I'm still into yesterday, still doing a lot of reading. It's going to be fast paced. I'm looking forward to it, and thank you all for your time.
well, that's great. Thank you. It's nice to meet you. We look forward to working with you.
Yes, as well. Thank you.
And Chairman Oakley, just to give the committee a brief update, we're of course going through all of the onboarding that goes with getting somebody up to speed and then scheduling, having both liaisons present during the session. Just based on budget logistics sessions, we're figuring out the best weekly chunks we can get in there, but we'll have that set out soon. And Chairman Ellis as well. I know that was something that the committee was interested in earlier this year. So we're going to go through some updates that are more Eastern Shoshone focused, and then it's all right, turn it over to Anita, and Anita's got a whole list herself of stuff she's been working on. So the first, and this is kind of rehashing things that we've spoken about a lot of previous committee meetings. There's a report that we've submitted to the committee. It was also submitted to the Select Committee on Federal Natural BIA for their support as well, taking that even further. Moving forward, there will be a budget ask from Governor Gordon for similar funding again to continue these efforts again because they were so successful. And then just to note again, there should also be in the meeting materials a joint letter. And we were able, fortunately, with both councils to have a joint letter with Governor Gordon and each council in support of federal legislation called the Veterans Support and Outreach Act, I believe. And that basically creates state grant programs for veteran service officer positions. Those positions help veterans apply for their benefits through the incredibly complex VA benefits process. Anita really drafted that letter, and it was one of her first things. So we just want to give her kudos for getting that done. And then that we were able to get both of those, we sent those letters to the federal committees in Congress, as well as our entire federal delegation. Moving forward, another.
Madam Chair, I know that looking at the date of the letter, it was sent fairly recently by congressional terms. I'm guessing you haven't received a response, but just thought I'd ask.
Thank you, Chairman Ellis. Yeah, we received confirmation of receipt but Congress has had other things on their plate, so I don't know where that bill's going currently, but we hope it moves. If it's something the committee's interested in as well, I think it's a bill worth looking at.
Great. Thank you.
Next topic is 4E, which is the partial reimbursement program from feds that state and tribal DFS programs can receive for child welfare programs. And just a continuing update here, we're still working with the Eastern Shoshone DFS. Anita will give some updates on Northern Arapaho DFS, but really on the Eastern Shoshone side, we're just still drafting the program contract where the state will function as a pass-through for monies from federal agencies then to the tribe. That's to reduce administrative overhead for the tribe. Of course, as we negotiate, things may change, but that relationship is going well. We really appreciate the help and support of the Eastern Shoshone tribe on that effort. And then Anita will touch on good work going on with the Northern Arapaho in a second. And then finally, just wanted to note that there will also likely be a governor's budget request for state funding for domestic violence service providers. Those funds get sent out to child advocacy centers, which help fund services for kids that have gone through trauma early in life, and then domestic violence shelters and domestic violence service providers like the Coalition. Those funds are needed to bring funding up to current levels based on inflation, based on severely reduced federal funding that's on the horizon. And this ties in here, I think, to this committee because it ties into MMIP. Trauma, domestic violence are both indicators of somebody going missing and are big factors in that happening. So that's the reasoning behind mentioning it here.
Question for you, Mr. Wen. Hasn't there been funding and we haven't been able to fill those positions? And I know you might be talking about something other than just a position, but hasn't there been that funding out there and we haven't been able to hire? Is that accurate?
And Chairman Oakley, I think on this one, because these aren't state positions, these are funds going to like the Coalition on Domestic Violence isn't a state institution, and it could be that they have hiring issues that I don't know. From my understanding, there hasn't been a state funding increase to these programs since around 2014 or earlier, maybe. Basically, there's been a glut of federal funding through VOCA that has helped stem the tide, but that is changing because that was a one-time bump that likely is now going to severely decrease.
Thank you, Mr. Wetland. And so basically to supplement what's been covered by the federal funds, but it is currently it's to continue to fund something that currently exists.
Correct, Chairman Oakley.
Thank you.
And that's all I have, unless there's other questions. For me, I can turn it over to Anita.
Chairwoman Oakley, Chairwoman Ellis, representatives and senators. Boy, I am nervous every time. So just thought I'd take a breath. So when I started as the liaison, I was given a list of priorities based on what the NABC, the governor, as well as the legislative body, or, the select tribal really found as priority. And one of the things that has continually come up as a discussion was housing. So I've definitely brought that up to all of you whenever I could meet with you. And it's an important topic to consider moving forward. Basically, the NABC had me research the ESB or the ESHA, Eastern Shoshone Housing Authority, that's under the ESB. and we went around and toured facilities across the state. So we went up to Gillette and over to Casper. And really in those tours, we were able to kind of just look at needs, costs, scopes, what the intake process looks like, really what the cost would look like to have one of those facilities here on the reservation. One of them in Gillette had a food bank, which is really a high need on the reservation. And then in Casper was the Wyoming Rescue Mission. So it was just a really awesome process. And it was really important, I think, for the council to be able to understand and see the scope. And I think they're going to be moving forward with something as soon as possible because we are getting into the cold months. While the East or the Northern Arapaho Tribal Housing has recently put in 20 houses, it was estimated in October that there's still 400 new homes that are needed just to meet on the Northern Arapaho side. So that's a lot of under housing. So that's something that we're
Question?
definitely. Yes.
Sorry to interrupt you. Just question. You said 20 houses and you said $400,000 was spent by the NABC, to save off obviously, winter months. But was that in new housing? How is?
That wasn't
how
just
are you
hotel
filling that?
costs. That was just in like hotel
Hotel
costs and
costs.
emergency needs right then and there to keep them from being removed from their homes.
Gotcha.
So.
Thank you. Go ahead.
Okay, and then the next thing is the MMIP. So I don't know if you know this about me, but I just go ahead and pull the trigger on things. And so the NABC asked me to facilitate an Ashanti alert training so that the tribe and the reservation, as well as the surrounding area, could understand what an Ashanti alert is. As you recall, in July, we got an alert and we're like, what is this, right? So it was really interesting. I kind of just set the dates, and it was great because the NABC, the state of Wyoming, the Wyoming Highway Patrol, we were able to have 2 trainings, and that was on August 7th and August 25th. I felt like the August 7th wasn't as like full as it should have been, but actually it was like awesome looking at the numbers after we had so many people there. I think we had close to 60 people that came. So that was police officers, so Lander PD, Riverton Police Department, BIA. We had Game and Fish. We also had leadership on the reservation. We had Clarence Thomas, the new director for the NADFS. So we just had a lot of people there. And from those 2 trainings, we've decided that we're going to try to have, it's called a CATE, which is a child abduction tabletop exercise. And that's with the DOJ. And that's going to be scheduled for March 28th. And so who's going to call the alert? Who's going to get called in? There's a lot of cross-jurisdictional issues that happen. So I think bringing them all to the table and to have a discussion about what that looks like, I think it should be really interesting. And they all seem to be interested in doing that. So NABC and DVS. So I'm already asking everybody for food and money so we can just get this taken care of. But I think it'll be a good, interesting coordination of really, who should be reached out to at that time. And then we went to the Western Governors Association conference last week. I was able to attend with Teresa Hischase, Councilwoman Hischase, and Councilman Mike Ute. He's on the Eastern Shoshone. I shouldn't speak on his behalf, but I just have to say, wow, he was so eloquent. He was so well spoken. He practically brought me to tears, as well as Councilwoman Hischase. They both just had such really strong messages at Western Governors Association regarding MMIP. They did just an excellent job. And what was even more profound, and I always worry about sharing this message, but the day before had been the anniversary of her sister's passing. And so for her to come and to speak so eloquently and so profoundly was just awesome. So those are some MMIP things that I was able to sit in on. What's exciting with the Western Governors Association is that, that resolution that was released in the summer is still out there. And so right now, I'm currently evaluating, not me, the office. I've pushed it over to Kit. I've emailed you, Senator Ellis, Chairman Ellis, sorry. So I emailed you regarding just the interest in the Badges Act, because right now that's what's out there, right? And I'm trying to see what we can do. But that Badges Act focuses on increasing coordinated access to MMIP case data, gathering data on federal law enforcement personnel needs, and creating demonstrated our demonstration programs for streamlining federal background checks among other goals. So it's really just interesting when you read that Badges Act that traditionally on tribal lands, it's 1.9 officers per 1,000 people, whereas at a national average, it's 3.5 officers to 1,000 people. So it may not seem like a big number difference, but it is a big number difference. So those are a few things. Oh yeah, NADFS. Oh my goodness, I'm so proud of the NAVC. They hired Clarence Thomas as the director, and I can't take any credit for the work that he's done, but I've been able to just kind of wait. They had an interim director and she was doing a good job too. So I'm not, but you know, she was ready to retire and they kept pulling her out. And he is just doing a really good job. He sent case files already to the state for review. And then all of the feedback from the state was just pretty quick fixes, he felt like. So right now, but it was pretty exciting to get feedback on. Any questions? All right.
That's great, Ms. Roman. Thank you for that. That's a lot of stuff you've been working on. Appreciate the update. I didn't realize that, I probably should have, that Mr. Thomas had taken over. That's an important area. So that's great to hear.
Yeah.
Any questions, comments, anything else? All right. Thank you all. Wait, hold on. Senator Barlow.
Thank you, Madam Chairman. So my question, and going back to the Veteran Service Office, the current Veteran Service Office that serves the tribe, the reservation, is that one of the state program ones or is that a federal funded one? Thank you, Madam Chairman.
Senator Barlow, sorry. It's actually one veteran service officer for Fremont and Teton counties. And so she's serving the whole area. And I think it's state, yes.
Follow up. Okay. All right. Thank you. I think that probably covers this topic, but this is the public comment. Any further testimony as far as the intertribal developments and efforts? Okay, so we're doing good. We're going to move on to cold case investigations, and I believe we will start with an update from LSO. Maybe not.
Good morning, Chairwoman Oakley, members of the committee, Katie Adams, LSO. Can
Gotcha.
you hear me okay?
Are you there, Miss Adams?
Yes. Good morning, Chairwoman Oakley, members of the committee, Katie Adams, LSO. Members of the committee, Katie Adams, LSO. Can you hear me okay?
We can, if you will proceed. Thank you.
Yes. So this interim, the Joint Judicial Chairwoman Oakley, members of the committee, Katie Adams, LSO. And earlier this month, the committee's final interim meeting, the committee voted to sponsor one of the two bill drafts with some amendments. So this interim, the bill draft the committee sponsored is 24 LSO 47 cold case database and investigations. Section earlier this month, Wyoming Statute 91, the committee voted to sponsor one of the two bill drafts to develop and maintain a cold case database. Under the amendment, bill draft, the committee cold case is defined to mean a homicide or felony such a homicide that remains unsolved for 3 years or more. In addition, DCI is required to adopt rules. That must be collected from law enforcement agencies maintained in the database. Finally, law enforcement agency has a cold case that was committed on or after agency first is required to provide information to DCI in the database. The bill draft requires the Attorney General's office to promulgate all rules necessary to implement the act. Attorney General's office is required to report rules necessary to implement the act on the status of the database not later than October 2024. Section 3 of the bill draft status of the database not later than $1,000 is appropriated to the Attorney General's Office for development of the database. And then any unexpended, unobligated dollars is appropriated to the Attorney General's Office must be expended to investigate development of the database. And then any unexpended, unobligated that the Joint Judiciary Committee did not sponsor this interim must be expended to investigate OSO 59 cold case investigations. Section that the Joint Judiciary existing statute sponsor this interim shall investigate cold cases 9 CI by investigations. And then that it may investigate cold cases referred to DCI by law enforcement agencies in the state. Shall investigate. Section 1 also generally stated that DCI may utilize the services and then that it may peace officers to assist in investigating law enforcement agencies in the state. And then it contains some requirements for retired peace officers. Section 2 of the bill would have authorized the AG's office to hire 2 full-time agents to investigate cold cases. And it would have included an appropriation for those positions. The amount for that appropriation was considered but not specified. In addition, Section 2 of the bill would have appropriated funds to the Attorney General's office to provide compensation to retired peace officers for cold case investigations. And again, the amount for that appropriation was considered but not specified. And finally, I would note that DCI provided input on both bill drafts during the interim. And with that, I would stand for any questions about the Joint Judiciary cold case bills. And again, the amount for that appropriation was considered but not specified. And finally, I would note that DCI provided input on both bill drafts during the interim. And with that, I would stand for any questions about the Joint Judiciary cold case bill.
Thank you, Ms. Adams. And join us up here. Do we need to grab another chair? Do you want to come up, Director? We can. All right, gentlemen, if you will introduce yourself.
Good morning, committee, Madam Chair. My name is Ronnie Jones. I'm the Director of DCI. Good morning. My name is Ryan Cox, Commander with Division of Criminal Investigation.
Good morning. Scott McWilliams. I'm the Deputy Director of DCI in charge of the Crime Lab.
Okay, and so just to kind of, I guess, stay on topic, since that LSO update was in regards to the Judiciary Committee work. I don't know if we have anything further on that or questions. Do you have anything you would like to testify about that to start with? Okay.
About why there were 2 bill drafts and why one of them, the Judiciary Committee, I think chose this one because DCI already thought they had authority for the second bill draft. Can you explain that a little bit?
Director Jones.
Yes, Madam Chair, we did testify during that that committee meeting, and my testimony was the provisions in that bill draft. I believe that we already had the authority to conduct those investigations. Whether it be at the direction of the Attorney General, or if we had the appropriation for to hire part-time investigators. I believe we already had the authority to do that, as well as the requirements that would have been placed on us to, conduct background investigations, not hire peace officers that have been previously decertified. Those are all things that we already would have done. And so it was my testimony that I believe that we had the authority to do what was already in that bill.
If the bill passes.
Yes, Madam
Go ahead,
Chair,
Director.
well, we don't know exactly yet what that will look like. There were a wide range of numbers that we were able to get on what the cost of that database would look like if we were to purchase one off the shelf, if you will. We did speak about the current missing person database that we have. Commander Cox created that, and I believe for that purpose, it's a pretty robust system. I think it provides the information that is necessary and helpful. The discussions that we've had internally have been centered around if we created our own cold case database in that same format, would it be capable of collecting the information that would be necessary to manage a cold case database effectively? So I believe the appropriation in that bill that moved forward was 150,000. That number was pretty much right in the middle of the estimates we got to purchase a program that would manage that information for us. So depending on what happens in the future, we're going to have discussions on whether we try and build our own, or if we need to look at purchasing one and what that looks like.
Okay, thank you, Director Jones. And do you think we've covered it, Ms. Sharp?
Thank you, Chairman.
Okay, are there any questions from the committee as far as the forensic genetic genealogy pilot program? It looks like Senator Barlow.
Madam Chairman, could I go back to the bill draft that the committee judiciary did pass?
Yes. I turned that off and on again.
Testing 1, 2. Thank you, Madam Chairman. So my question was, and I know the bill was amended. We do not have the amended form, but did I understand that 3 years is now the cold case definition? Is that accurate? And I guess my question is how many cases do you have on your current file or in law enforcement one that are already over 3 years that are considered cold, and how are those actually flagged, and whether it's a
Madam Chair, Senator Barlow, DCI currently is involved in, I believe, 16. What we are the main agency on 16 cold cases throughout the state. It's going to vary from agency to agency whether there's a flag in their system on what makes a case cold or not. We estimate that there's approximately 150 current cold cases in Wyoming, and that information would be specific to homicide cases and would date back to 1965. And that's based on UCR, Uniform Crime Reporting data. I think that we would be able to address, the issues of flagging with local agencies within the rules. But I do think that it would depend on each individual agency whether those cases are flagged currently, or what their definition of what makes a case cold. And there's really no way for us, at least where we stand today, to know how many cold cases each individual agency has. And I would venture to say that each individual agency would probably have a difficult time answering that question today, because it just varies so much from agency to agency. And RMS and report management systems have evolved so much in the recent history I think the information, you know, if the number is 3 years, I think that these agencies would be able to go back much easier now, you know, back to at least where they digitized all of their police work to say, here's how many we have since this date. But prior to that, it was all paper copies. And I think that there's going to be a lot of cases that have been forgotten over the years just because there's constantly new ones coming in, and, you know, turnover in staff, and cases that just haven't been looked at for a long time for any number of reasons.
Director Jones, further questions from the committee? All right, thank you. So, I mean, it looks to me, do you have anything further as far as the cold case? It looks to me that we are on to an FBI.
Odette knows more about it than I do, but we'll try it one
See
more
if we
time.
can.
Yeah, I
hear
think
her.
the internet here just isn't.
So we are
too
going to go
strong.
ahead and go.
Yeah,
okay.
we'll go back to the genetic one.
Perfect. Thank you for keeping me on track, Mrs. Sharp. Ms. Adams?
Chairwoman Oakley, members of the committee, this is 24 LSO 335 Forensic Genetic Genealogy Pilot Program, Working Draft 0.5. Generally speaking, the bill draft appropriates $150,000 to DCI for a forensic genetic genealogy pilot program that would run for 5 years from 2024 to 2029, 2029. Starting on page 1, line 11, the pilot program is created and DCI is required to establish and administer the program. Turning to page 2, line 4, DCI is authorized to use the funds for 2 purposes. So first, DCI may use the funds for forensic genetic genealogy to assist in generating leads for criminal investigations or identifying human remains in investigations that are conducted by DCI. And then second, DCI may use the funds to award grants to law enforcement agencies in this state for forensic genetic genealogy to assist in generating leads for criminal investigations or identifying human remains. DCI would be required to establish an application process for the grant program. Starting at the bottom of page 2, the pilot program would terminate on June 30th, 2029. On page 3, section 2, the bill appropriates $150,000 from the general fund to DCI to operate the pilot program. Section 3 then requires DCI to promulgate any rules necessary to administer the program. And then section 4 contains an effective date of July 1st, 2024. And with that, I would stand for any questions.
Ms. Adams, question from the committee, Representative Chestic.
Thank you, Madam Chairman. Ms. Adams, I see you're using the term forensic genetic genealogy pilot program. Forensic genetic genealogy is not defined in this bill. Is it defined elsewhere, or is it something that's commonly understood in the field that I don't understand what it is, but others wouldn't? Because I'm not quite sure what we're authorizing for forensic genetic genealogy. What does that encompass?
Ms. Adams, if you would like to answer.
I think FGG there's a definition out there. There are several states who have set up pilot programs similar to this, including Congress. So I do think the term is out there, and I think it is a term of art. And I just want to thank Katie for a good job in drafting this bill, and have visited with Director Jones. Really, the intent of this isn't to establish or put more work on DCI or establish new FTE. It's really to be a snapshot to provide additional funding for very specific types of research that we know vendors out there exist. if DCI can utilize it, there'll be funds available. If local law enforcement agencies, they can go to DCI, apply for the funding. And there's a reversion clause. So if these funds are utilized, great. If they're not, they go back to the state. And, if there's more need than this appropriation can handle, we can always revisit in the future to see if the program worked and if it's effective. So I just wanted to provide that context. This is a direct result of the testimony we heard at our last hearing.
Further questions? Okay, hold on one second. Okay, thank you. So, DCI, do you have further testimony or comments as far as this program, this bill? Director Jones?
Madam Chair, I guess my comment is that we have a grant coordinator within DCI who manages all of our grants, and she is very familiar with we actually have some, I guess, go-bys, for example, on what a grant application would look like. So I do believe that we would be able to manage this if this were to pass. I guess I would note that if this were to become law, we would work closely with the chiefs and sheriffs across the state to promulgate the rules to make sure that they are in line with the needs that the chiefs and sheriffs see for their individual jurisdictions. And the other thing that I wrote down on here, I guess, for consideration for the committee is I was trying to anticipate some of the what some of these requests might look like. I think the obvious one would be the funding to work on these cases on their own. So that's probably not all encompassing of the requests that we'll get for this money, but I was just trying to think of some of the requests that we maybe get that are kind of outside of what's outlined within the bill draft. And I guess also, just so you know, I did bring along, obviously, Deputy Director McWilliams. If there's any technical questions about, what this type of analysis would look like and what the needs would be on the front end in order for the analysis to be successful, if there's any questions of that nature.
Thank you, Director Jones. So back to what you started with, generally what I'm hearing from you, I think that you're comfortable with this moving forward and think it might be a step that could help, that would be something in the right direction.
Sure, Madam Chair, I would agree with that. Yes.
Thank you. And then Deputy Director McWilliams, do you want to go ahead and speak to what Director Jones was just referring to as far as the, I guess, administration of the program?
Sure, Madam Chair, Committee. The forensic genetic genealogy is a newer technology that I think it doesn't solve things on its own, but it's a piece of the puzzle that really works with our criminal justice system and how evidence flows through our laboratory, in particular in the DNA unit. I started in the DNA unit in 2005 and worked several years and then supervised the unit for approximately 5 years before becoming deputy director. So I'm very familiar with the workflows in the DNA unit. And I would envision this as being a system that complements our laboratory and the workflow of the criminal justice system. As pieces of evidence come through and their biological analysis is requested on certain types of cases, if there's a CODIS eligible profile, and that's the FBI's combined DNA index system, that we use on any eligible sample, everything that is either linked to an individual or not linked to an individual that qualifies to be put into that database is put into that database. And even the solved cases can help link to unsolved cases. We also have convicted offenders from a law passed by the legislature in 1997. In this system, CODIS sometimes doesn't give a hit if someone's not in the database. There's not, I think in those dead end cases where we do have enough material, enough genetic material that's not totally degraded and there's enough DNA there to analyze. You need about a nanogram of DNA for forensic genetic genealogy. Some of the touch DNA samples that are submitted to our lab don't have that right now. You need to have the perpetrator, the person of interest that you're wanting to find. Not usually a problem in unidentified human remains because that's a single source profile. But in forensic samples, the person of interest needs to have the majority of the DNA in that sample. One example that I used with Director Jones the other day was sometimes we can, with our technology in the crime lab, we can take a 4-person mixture, say from theoretically a gang rape, where we would have a victim and 3 perpetrators, and there's all 4 DNA profiles are mixed together. But just so happens that we know who the victim is. And so with we have a highly complex computer program that can subtract out DNA profiles from mixtures. And so with this technology, we can remove the victim's profile. And at some of these cases, we find a couple cigarette butts at the scene that have male profiles on them, and they're in the mixture. And so we can sort those out, subtract the victim, subtract 2 other people. And that leaves us with the 3rd perpetrator. And what would go into CODIS as a wonderful profile would not be a profile that you could put in genetic genealogy because that's not a majority of that mixture. If you sent that out, you would get just a mush of DNA that doesn't give you any leads. And so we need to see the majority of a sample be from that person of interest. That really limits down the samples that can be sent out for forensic genetic genealogy. But nevertheless, these profiles exist and sometimes they don't hit in CODIS, and this would be a wonderful, powerful piece of the puzzle to help make leads.
Deputy Director, any questions for the Deputy Director, Senator Barlow? Go ahead.
Madam Chair. Madam Chair, I wanted to thank DCI. Every time I call, always really responsive and helpful. Director Jones did tell me that, right now, based on the Uniform Crime Report, that they have 150 cold cases. I don't think every single one of them would have the necessary DNA that could be submitted for this. So in trying to come up with the right dollar amount, this is a very honest, I think, wanted to give some context of why the 150,000, that was a me number, not an agency number. We talked about it a lot, but that at the end of the day was the amount that I thought was reasonable.
That's great. Co-Chairman Ellis, Senator Barlow.
Thank you, Madam Chairman. So much like the cold case discussion where a database may be something of interest, but you already have the investigatory power, you felt, I think, Director. It seems to me that you probably already have this power too. What we're really looking for is a funding source and a vehicle to do that. Is that accurate, or is this, because this does not give any statutory authority, at least in my view, it's all non-codified statute. So really what we're doing here is a funding authorization, for lack of a better description. And the second one would go to the co-chair's point about the funding is 150,000 over 5 years, $30,000 a year. How many tests can you actually do for $30,000 a year? Thank you, Madam Chairman.
Jones, do you want to take that? Go ahead.
Madam Chair, Senator Barlow, I would agree with you. We already have the authority to do this type of testing, and we have done it in previous cases. So I believe the reason why the funding would help is because this type of testing is very expensive. Depending on the work that we would be requesting from, whatever company we sent the sample to, the cost is going to be on the low end $3,500 per case, and I've seen numbers as high as $10,000 per case. I believe the numbers we provided to the Judiciary Committee were 3,500 to 8,000 per case, but we've actually seen since then higher numbers, and that all depends on what it is we are requesting them to do. So 3 cases per year would be probably a rough estimate.
Mr. Chairman, a follow-up. I think the bill is drafted in such a way that it doesn't have to be spread out, like there's only an allocation for each year. I think if you, within the first 2 years or first year, could have enough of requests, you could spend that money. It's just, if there isn't enough requests, I wanted to keep it open long enough so that at some point we look at the program and say, okay, this was utilized, maybe we should fund it more. But I think that was how it was drafted. That was the intention.
Do you have any further question or follow-up, Chairman? Excuse me, Senator Barlow. So I've got a question. We've talked about it. I feel like we've kind of gone back and forth on this as far as, whether you already do have the authority. So just directly, do you think there's a benefit to having this specific authority, creating this specified program in regards to this? Or do you think it's superfluous and unnecessary?
Madam Chair, I don't think we need specific authority to be spelled out. It's just another investigative tool that is already in our toolbox. The challenge generally is going to be, how do we fund it when we need to use it, if that makes sense. And I'm not sure if I answered your question, but I think we already have the authority to do this type of work, as all the local agencies as well. They would have the same authority to do it, just like we would currently.
So you're saying that basically just an increase of funding would get you here, and that you don't feel like it needs to be carved out as a specific pilot program?
Well, Madam Chair, I think that's a question for the committee. I think this investigative tool would probably be used more often if there was the availability for local agencies as well as DCI to be able to use it because of the available or appropriated funding.
Thank you, Director Jones. And that's what I'm getting, because that's what I thought I was maybe hearing you say. You just absolutely didn't need it, but it seems to me that if you say here, this is a technology that's available and funded, that it's more likely to be used. So thank you for that, because I think of this as far as criminal justice, an exciting direction. There have been some interesting, very long-term cases that were unsolved that have been solved, using this. So I think it's good to stay on the forefront and jump in with technology and maybe technology is not the right word, but avenues that exist as we get better at DNA analysis and in different ways of doing that. So I think it's great. So any further questions for this panel at this time?
Madam Chair. Memo from LSO and the concern on this topic with the for Fourth Amendment rights, and specifically the concern that maybe with this type of technology that a person can may lose their expectation of privacy. like LSO here, I'll just read it. A person loses an expectation of privacy that he may have had by voluntarily providing the DNA. I sat in a MMIP meeting during the summer, and this was discussed, and it was brought up, which sounds really great when we're looking at solving cold cases. And I watch the murder mysteries and things, and you see how amazing things can be done with it, and that's really wonderful. But there's also a flip side of that potentially. In the MMIP meeting, the comment or the discussion was brought up. Well, wouldn't it be great if everybody just would go and submit their DNA? Then we would just have everyone's DNA. And I can't remember exactly. It might have been Ms. Romans, but someone in that committee said, I'm not so sure that our members, our tribal members, and just people in general are always wanting to willingly submit their DNA just because. And I have that concern myself. This can be used for really great purposes, but there's a flip side to that, and anything that could be used for you could also potentially be used against you. And so, again, it's probably not in relation, as this is not a statute change, but I don't know if anyone has any comments or thoughts on that as constitutionality of Fourth Amendment rights.
And Madam Chairman, can I just add a little bit? You didn't receive that memo. It was a confidential memo to the committee, but it was just to explain that we anticipated that DCI will, these are I'm sure if they, with other programs or other times when you use this type of testing, that you take into account those Fourth Amendment concerns. Maybe you can expand on that. What do you do?
Director Jones.
Madam Chair, Representative Penn, thank you for those comments, and I agree with what you're saying. And we've talked about this internally already. Our plan, this was not provided to the committee, but in November of 2019, the United States Department of Justice put out an interim policy addressing, and there's a focus on balancing the interests of the government to, solve these types of cases with privacy interests. Now this wouldn't necessarily have to guide our practices, but what my plan would be to use this document to promulgate our rules, to make sure that our rules are in line with what the DOJ's policy is, to make sure that only the most violent cases or whatever the appropriate cases are being submitted for this type of testing, and that those privacy interests are kept as a main concern. The other thing that we would do, to make sure that our rules are constitutional and fair, is that we would be in consultation with our legal counsel at the Attorney General's office, not only at the beginning of the process, but throughout the whole process, to make sure that there's an attorney who is reviewing our rules and making sure that what we're doing protections.
Thank you, Director Jones, and I'll go ahead and weigh in on this a little bit here, as it's something I deal with every day. Fourth Amendment issues are certainly nothing new to the criminal justice system. In fact, that's something that's dealt with on a daily basis. So what you're looking at is just a continuation of law that already exists, as far as probable cause, warrant requirements. All of these things go through judges, go through trained prosecutors, as well as law enforcement, with all of them having their eye towards the constitutionality of the process, because it's their job. How law develops in relation to Fourth Amendment is via court cases, a case-by-case analysis. And because of that, like in the criminal justice context, every defendant has a lawyer. And so every case will have a lawyer with their eyes on it, looking to see if maybe there was something that would be considered a Fourth Amendment violation. Then they would submit that to the court. It would be go in front of a judge. And should there be something that in an individual case was a Fourth Amendment violation, a judge would find that. That case would be thrown out, and then we would have that knowledge going forward. As a good territory, we can go forward, and as I said, you look at those issues individually as they go forward. I don't see there's any reason that we wouldn't pursue this technology, which really dovetails with DNA technology that we're currently and has been used very significantly. So with all that, it's always something that we keep our eye on, the Fourth Amendment. But I don't think it's anything at this level as far as setting up and going forward with this technology and using it that would stop us from doing that. So that's my take on it. Okay.
Madam Chair.
Representative Peck.
Is there a way that I can get a copy of that interim report or policy? If I can, even just the link or something, if it's easily found. Thank you.
We can provide that to the committee.
And I believe
Yes. Okay.
through LSO. Okay, thank you. So any further questions? All right, thank you, panel. And so
Chairman Oakley, can I just add that there is actually a link in the memo to the DOJ memo.
great, thank you. So we have that, that's been provided, that's great. I would like to know if there's any, did you want to, okay, perfect. Director Chambers is going to address the committee, and then after that, if there's anybody that wants to make public comment, we'll go to that. So with that, if you will introduce yourself and go ahead, Director Chambers.
Good morning. My name is Kara Chambers. I'm the Director of the Division of Victim Services, but here in my capacity as Chair of the MMIP Task Force for Governor Gordon. Obviously, these gentlemen, this is their deal. They explained mostly, but I did want to touch on a few things that I think this bill is needed for this pilot program. If you recall, I did bring the concept of investigative genetic genealogy to the MMIP task force because I had attended a seminar in Colorado. The key piece that our lab doesn't do is the genealogy component. This is a person who will, based on DNA results, will be able to use sources to determine that we believe ex-offender is the second cousin twice removed of this person who voluntarily consented to have like an ancestry, or 24 or 23andMe, excuse me, type thing. But more to the protections that I wanted to alleviate some of your concerns. So that would be a voluntary knowing consent for this to be used for law enforcement purposes, along with all the other Fourth Amendment protections that Representative Oakley. But I did want to make it clear that it's not just if you do a 23andMe that you're automatically law enforcement can search it. I believe law enforcement would love that, but that's not how this works. So I did want to make sure that you understood there was some provisions for that. And in fact, our state, which I thought was bizarre back in 2016 because I didn't understand this, but Wyoming has actually some really specific state laws on individual protections when you submit to those sort of genetic testing, which again, at the time I was like, what are we doing? But I just wanted to alleviate that. So I did want to address that the key component of this bill is the money for the pilot project, and to have that genealogist who is the one who's searching, vital records, marriage records, statistics to try to narrow down to a suspect that's not part of what the DCI lab is doing. So just wanted to clarify that.
Thank you, Director Chambers. And I think that's a good point. We'd actually, that it is very much discussed on all of these when you're submitting your DNA, there's a whole, like, if you consent, what you consent to. And we discussed it actually with the gal who presented here last time. She had tests and it was she was even talked about that very clear on, you decide whether, whether it would go into a public database or not. So certainly that is, I think, being addressed with it as this technology moves forward. So thank you for that.
Thank you.
Madam Co-Chair.
Madam Chair, I wanted to just thank Director Chambers too. I listened in as much as I could to the MMIP task force yesterday. I think the intent of this bill also is just kind of be something that can be communicated to victims' families. And I think that there might be a perception that not everything is being done to identify certain remains of loved ones or using all the technology available. I think having this kind of carve out would allow for that transparency. So for victims to know, whether or not there is enough usable DNA, or it's also written for victims too. So really to try and support DCI, but also as a tool that victims can start asking questions about whether or not their case that they're involved in can be utilized this technology. So with that, Director, if I missed anything about the task force meeting, because you did talk about some of the bills going through judiciary. And so if you want to give us a quick recap on anything that was discussed yesterday that might pertain to cold cases, that'd be great.
Madam Chair, Co-Chairman Ellis, I believe they've covered it, and I know you guys have a very busy schedule, but I thank you for the opportunity to speak.
Director.
Apologies, members of the committee, Co-Chair Ellis. I just wanted to say we, of course, as on behalf of the governor's office, while we defer, of course, to what DCI needs on administrative budgetary considerations, we do support efforts like this to help solve cold cases and MMIP cases in Wyoming. So just input on that. I think there are ways to work around legal issues on a case-by-case basis, and this could be a good opportunity.
Further public comment as to this bill draft and the forensic genetic genealogy pilot program? Okay, I'm sorry. Okay. Please state your name and then proceed with your testimony.
Can you hear me? Good morning, ladies and gentlemen, the Select Tribal Committee and everybody in attendance. My name is Nicole Wagon. I'm here today as tribal member of the Northern Arapaho tribe. I'm not sure if you guys all know me, but I've been pretty active with MMIP. As you know, it's all in the media. My oldest daughter was murdered, Jocelyn Watt, and we're receiving justice for her. My second daughter was missing and I strongly feel murdered. And I'm here today, not just for myself, but others of concerns, because I started MMIP Wind River, grassroots level. I've been an active spokesperson in this area, traveling, speaking, raising awareness. I've organized marches, MMP awareness and powwows, and met with local law enforcement, city leaders, and experienced knowledge of what connects the hearts of the MMIP families. So I'm just not here for myself, I'm for others. I strongly believe that with MMIP Wind River, it's for all with the epidemic that's occurring across our reservation as we speak. Not just Arapahoes or Shoshones, not just females, but males also. So with the cold cases, I'm glad that you guys are doing this bill. At the same time, within my heart, it's really hard of the calls that I receive, giving them hope not to give up. And trying to put things in place to be pro and preventative as well. I work with Miss Kara Chambers. We work together to implement the Ashanti Alert. How do we get to the pro and preventative? How do we make it safe again? I'm not only here for myself and others, but for my grandchildren, for them to have a safe environment, and all children. And I personally would like to thank Mike Ute for supporting me on my endeavors that I've done in the community. And it's much needed. At the same time, with the cold cases, for right now, my focus is on my daughter Jade's case of how it's a cold case. I was invited to the NIAC meetings. I went to the NIAC meetings, and testified there. And within my testimony, I was really upset with our leadership because, again, with our statistics, our numbers, we have 710, I believe, missing and murdered. There was only 5 people at that NIAC meeting testifying. There should have been more. So I don't know, with the lack of communication from everybody up of how we're going to change this. However, because the movement, MMIP, Wounded River Movement, and others, change will happen from the ground up. And they're going to continue to move forward with the help of other MMIP groups and organizations. I'm connected to so many people, it's not even funny, it's a blessing. Where I said in the MMIP task force meeting yesterday, I personally don't feel the support for the victim and victims' families. But however, I do have support in Washington, DC, Washington State, Arizona, Montana. So that's what keeps me going in that strength, to keep up, keep fighting, making a difference. Whatever we can put in place to make it better for others, to stop this epidemic, and to put a stop to all the drugs and alcohol and all these factors with the how it hurts. We hurt. And in the beginning, when all this happened, when the governor personally called me to be a part of this task force, my daughter was murdered January. Then the task force came May 5th. And that's where it all began. And I've been on board ever since. I've been committed ever since. And I'm going to remain committed. So with that being said, my concern is with the cold cases with the FBI. I've been pushing to make sure that components are in place. The victim's advocate, those are the link to the families to reassure them that their case and needs are being met, and the communication, because they're not being heard. The victim's advocate is a very crucial component to these cases. They're the ones for the go-between to assure the family, yes, we take you seriously. Yes, you count and matter. Yes, all the tips that you have, we'll make in consideration. So with the FBI, is that all implemented here on the reservations? Because we're talking about 2 different jurisdictions here. So with the state side, I applaud the state because I have good communication with them. At the same time, I got so many calls. We've never solved anything on the Wind River. And why is that? Why is everything swept under the rug of the Wind River? It's time to make a change now. It's time to solve this and this behavior and to say it's not okay. And I keep standing up and speaking up because I don't want this to fall on deaf ears and to say, hey, it's normal. Oh, somebody just now got killed in the city of Riverton. Somebody we just now found under the bridge. Whose jurisdiction? Where's the follow-ups? And that these families count and matter. And it's really hard to reach out and say, come speak. They're in grief. It's trauma. Not everybody can get up and speak and talk about their loved ones, one step at a time. For them to even be at a march is a step towards healing. Ask yourselves, I imagine you guys are family daughter was executed. Could you handle it? There's no book written on this. What to do, how to do it, how do you move forward and work together? Could you handle it? And there's many, many other cases. And we're all related some way, somehow. And to work together to make it better as this reservation as a whole. So I stand here today and hopefully implement with the FBI. That's my concern here, the FBI. Everything that's going to be stated with the policy and the numbers and the bill, I mean, that's good. That's talking about it, but what's going to put to action with the FBI and the federal? That's my concern. And right now, my daughter is considered a cold case, but my focus is it will be open again. And I met with so many officials at the NIAC meetings, keeping those communications open. The good that came out of that with my testimony, they reassured me that we are going to have an MMIU unit here. It's a need. And I'm really grateful to know that it is Mrs. Makeshine that is the MMIU unit, MMIU representative for this reservation. So with that being said, if I don't stand up and speak out, I'm not going to make a difference. And I do it because my daughter's lives counted and mattered. To make it on the positive. To make it better for others. So with that being said, thank you for allowing me to talk and being here. And I take these matters very seriously. So, ho.
You, Ms. Wagon, questions for Ms. Wagon? Thank you for being here. Any further public comment as it relates to the cold cases? Senator Barlow?
Thank you, Madam Chairman. Thank you very much. My heart aches for you and for those many other families out there. Hopefully we can make some difference. Madam Chairman, would it be okay to actually ask Ms. Chambers to come back up and kind of explain the jurisdictional issues that nation? So if that's appropriate, Madam Chairman,
Sure.
I don't know, but I just, something was brought up with a jurisdictional issue, and I think that there's some value in at least me understanding that.
Yeah, thank you, Senator Barlow. Certainly, Director Chambers can come up. We are going to hear from, I think, some from the FBI, and then, yeah, and then, so that might be addressed then. And then also, I know, I mean, as far as our state DCI and their we can get that information. So go ahead if you have anything, go ahead.
Thank you, Madam Chair, Senator Barlow. Well, maybe I'm not the best person to speak about it, but yeah, always an issue of which case. Obviously, Wind River Indian Reservation, law enforcement is actually through BIA and they have their own agency, and I certainly can't speak on behalf of them. I can let you know that the state's interaction with both the FBI and the BIA is quite good in the sense that my office, the Division of Victim Services, funds crime victims compensation across the state. And so we work with the FBI agents and advocates on the Wind River if there are victims of federal crimes that occurred on the reservation. Now, I think the jurisdictional question you have is obviously this. I feel like that, I don't know what happened. And, this is a state bill and this would be a pilot project for local agencies. So obviously it is weird when that happens. So there's always going to be that burden, but I would actually let whoever else is here with the federal agency speak on the interaction. But I do believe Commander Cox could maybe speak to their interaction, because I do know that he testified yesterday at the MMIP meeting when he was talking about cold cases about the interplay between the FBI and DCI. And so I'd defer those law enforcement questions to them. But just to let you know that the State Victim Services does work. I've known Nicole for many years. We've worked on obviously her daughter's Jocelyn's case, but I'm aware of her daughter Jade Wagon. And again, we do have that state interaction with federal crime victims. So whether if that makes sense, I hope that helped a little.
Barlow.
Thank you, Madam Chairman. First of all, this bill draft does not speak specifically to cold cases, so I want to make sure that is at least clear. If we want to be true to what the Judiciary Committee, we would have to at least synchronize those a little bit. But I guess, is there an MOU in place where we can actually, state can actually come in and assist with type of
mutual aid agreements? I'm not sure on the status of those in our state.
And Senator Barlow, unless you have any follow-up for Director Chambers, again, we are going to hear from the FBI. And I know that they work extensively, since they're here in Fremont County, as far as the multi-jurisdictional things like that. So we'll have an opportunity to dig into that a little bit if you want. Thank you. But I guess I'll ask this, Senator Barlow, because on this I was going to close public comment and move to the bill, but do you want me to call up somebody before we do that? Okay. Thank you. Okay. Last call for public comment on this. Okay, I'm going to close public comment as it relates to this. Committee, what's your pleasure? Second. The bill has been moved by Senator Barlow. It's been seconded by Co-Chairman Ellis. Representative Chesty.
Thank you, Madam Chairman. And I am debating whether I should support this or not. Number one, I absolutely do support using this technology and think we need to fund it. And I think the intent of the bill is great, and I support that. I'm wondering if this is the best way to go about it, because if the department has the power right now to do this, what does this add? Not sure. And how is this better than having a budget amendment and having a footnote adding some money to the budget, which budget session's coming up? Maybe we should just do it through the budget process. My concern is that I'm always looking for unintended consequences. My concern is that this might create limitations that aren't intended. But the limitation that I think might be seen is, if you look at section 1, section 1A seems to say, this is the way we are going to do forensic genetic genealogy for the next 5 years, right? And so we create this pilot program, we fund it. Does this take away the right of the department to use other funds for these purposes? If this says this is the pilot program, this is the way we do it, and for the next 5 years interpreted that way. So that's why I'm wondering, and again, I'm not sure if I'm going to vote yes or no, but I'm wondering if handling this in the budget process would keep the flexibility the department needs to use funds for these purposes, and we don't have to worry about the thing expiring at the end of 5 years. That's my concern.
You, Representative Chestic. So I think there's absolutely benefit in taking this step forward. I think it's obviously something that they even mentioned that it's a pilot. It is taking that first step, and then as it goes forward, we can, as a legislature, fund and tweak as necessary. I know there's reticence. There just always is on the part of executive branch and different agencies weighing in on policy, but I do believe that we got there, that we heard from Director Jones and the governor's office and pretty much all the stakeholders here, that they did see value in it, and that I think starting to recognize it as its own program and having this bill draft creates a lot more, has the ability to create a lot more structure than to just try to add $150,000 and see if the appropriations committee understands it. What we've done here, of course, is we've listened to people who run these programs, and we've listened to the stakeholders, and we heard there's value in it. And I put a lot of weight behind that testimony and what we've heard. So I think it is a necessary step. I think it's an important step. And I think this technology, or probably the incorrect word, but this ability to look at evidence in a different way is an exciting direction that can help solve cases. So with that, I'm in support.
Thank you, Mr. Chairman. To just make it clear, I don't think that this will inhibit DCI's authority to spend money, how they spend money. If they want to use a different pot of money that they get through the general fund on a FGG project, they can still do that. There's nothing in here that prohibits that. And the distinction between this and a budget footnote is our budgeting is biennial. We do it for a 2-year cycle. So we would do $150,000, and that money would need to be spent in those 2 years. I think what this is intending to do is to complement the work done by the judiciary to create the database. Right now, we don't have that. So when I asked the director how many, cases are out there, program that time also by using the word pilot, gives us the time to reevaluate. Are we finding that there are a lot of cases where this technology could be utilized, or this protocol? We'll have that information, and we'll hear from victims. And if we need to expand the program or make it permanent, part of the regular budgeting process, that's all available in the future. But you don't get all that done without putting your toe in the water. So this is an appropriate way of doing it. I really want to commend LSO. I think they did a good job in how they drafted it. They give lots of leeway to DCI to make sure they do the rulemaking in a way that is flexible and administrable to them. So would urge your I vote, and to the extent if you stew on it more and want to see an amendment that needs to be added clarifying authority, that this isn't intended to infringe on DCI's existing authority to spend money how it wants to on FGG, we can add that in there. But if we kill it today, then we got to bring it as an individual bill. So I would urge an I vote.
Your comments? Senator Barlow.
You, Madam Chairman. So certainly as the novice on this committee, and with these very heart-wrenching and challenging issues, and I thank the folks that do have the courage to come here and share their stories. It's certainly something that I think is more than worthwhile advancing. I respect there are other avenues to accomplish this, including the budget. And what I'm going to suggest is if this bill passes committee, we also forward it to our appropriations committee so they can consider it within the budget process. And then we have 2 horses in the race instead of potentially 1. And then I would also suggest, and while I'm not going to make any amendments to this bill now, there's also with the cold case database bill that the Judiciary Committee, I think we need to also look at the parallel tracks of these two issues and how they may interact. And I'm not suggesting we tell, well, I guess I can suggest we tell, since this is a legislative pilot program, is that we actually maybe prioritize cold cases or missing and endangered, missing and murdered and missing and persons cases within this, because the way this is right now, it's the money can go out for any case. And so I think if we really want to focus it to what I think the intent of this discussion has been this morning is there may be some refinement that we do as this process continues into the budget session with both bills and within the budget process. So like I said, very supportive conceptually. I think more refinement maybe as we go.
The amendments. So is there further, Representative Chestic?
Too soon. I do have an amendment. But I'd like to propose at the bottom of page 2, add section D. Nothing in this bill shall be construed as a restriction on the division using other available funding to conduct FGG analysis.
That amendment has been moved by Representative Chestic, seconded by Senator Ellis. Discussion.
Could you just read it one more time?
Yes. Nothing in this bill shall be construed as a restriction on the division using other available funding to conduct FGG analysis or forensic genetic genealogy analysis.
You have that? I think I'm going to be a no, because I think it's stating what already exists. But I mean, either way, I guess, however you want to vote. So any further comment on the amendment? And I think this is the first time we're voting. Is Senator Case? I'm here. He's online. Okay, so just to make sure he's included.
Maybe just ask if he's.
Yeah, if he has it. Can you hear us, and are you ready to vote, Senator Case?
I'm here.
Perfect. Okay.
We're on the
So I'm gonna
amendment,
call
correct?
for the ayes and the noes on the amendment. All those in favor say aye.
Aye.
Aye. Aye, Case.
Did you say aye, Senator Case?
I did, yes. We're on the amendment, correct?
Okay. And
Yes.
and the nays, I'm a nay, so.
Aye. Aye, Case.
That amendment has passed.
I did, yes.
Got it. Thank you, Senator Case. Okay.
Yes.
We heard you, Senator Case. We're good. The amendment passed. So now we're gonna go on to the bill, unless there's, I got it. Unless there's any further amendments. All right, so voting on moving the bill forward. All those in favor say aye.
No.
Oh, yeah, that's
Roll
right. It's a
call.
roll call. Sorry, thank you.
Madam Chair. Oops. Senator Case.
I think you're like 30 seconds behind us, Senator Case. We're waiting for your vote on the bill.
Chair, we could also continue with the vote and leave the vote open and wait for Senator Case to log his vote if you'd like.
Representative Chesty.
Aye.
Representative Penn.
Aye.
Co-Chairman Ellis.
Aye.
Co-Chair Oakley.
Aye.
As of right now, there are 5 aye and waiting on 1.
Madam Chair, we can say that the bill passed and leave the vote open if Senator Case would like to weigh in or cast his vote when he is able to reconnect. And then move on.
And does it look like he's connected? I think he's just got a delay. I think if we wait.
It says he's
Just
connected.
give a second.
Yeah.
One last time, Senator Case. Okay, so we'll leave that open for his vote. But going forward, that passes. Okay, so along the same lines of this sort of broad category, we will have a representative from the FBI come up on specifically on Native American cold cases. And I don't want to put anybody on the spot. The BIA would certainly be welcome if they feel like they would like to weigh in on this as well. All right, good morning. If you would introduce yourself and then go ahead and proceed with testimony.
Morning, my name is Jedediah Oakley. I'm the supervisory senior resident agent for the FBI here in Wyoming. I've been provided a number of 4 approximately talking points. If you'd like, I can just start and go through those. Is that acceptable?
That sounds great. Thank you, Mr. Oakley.
Thank you. The first in regards is to if we can provide an overview of the types of crimes that we are seeing on the Wind River Indian Reservation. The exact numbers vary year to year, but traditionally it's % domestic violence. And then there's a couple other smaller categories, which sometimes we have and sometimes we don't. It should be noted that for death investigations, this includes not only a homicide investigation, but other types as well, maybe an unattended death or suicide or things like that.
Madam Co-Chair.
Thank you, Madam Co-Chair. This you went so fast. Did
Oh,
you
I'm
get
sorry.
this information from is it the Uniform Crime Report that the FBI compiles
No,
from last year?
This information is actually from our own stats here at the Lander office, which has sole responsibility for the FBI's investigations on this reservation.
Okay, thank you. Go
Would you like
ahead.
me to go through those numbers again? I'm sorry.
Yes, please.
Okay, sorry. So for this fiscal year, the percentages as far as the open cases that we have, 40% involve sexual abuse of a child. 19% are assault. 11% death investigations. 8% rape. And 6% domestic violence, which typically is a strangulation, but due to the laws, they're categorized separately. It should be noted that for the death investigations, this includes not only homicide cases, but unattended deaths or suicides of things like that. So for this fiscal year, we opened 10 death investigations, 4 of which had been ruled homicides. And those percentages don't add up exactly to 100. There's a couple outliers here and there that may get open where they're a financial thing or something like that. But that's typically what we see for our top caseload. Secondly, it said that Wind River is sometimes portrayed as one of the more dangerous reservations in the country, and asking if that is an accurate or an inaccurate portrayal about using the numbers we see in the UCR, if crime is staying the same, increasing or decreasing. So for purposes of our operations and investigations in Lander here on the Wind River Indian Reservation, we don't typically compare those numbers to other reservations across the country, simply for the fact that that doesn't really help us make any decisions or operations or investigations that we're focused on. We have the cases that we have based on the incidents that happen, and that's where we focus our attention. From our perspective, we can compare the total case numbers that we open over different fiscal years. And over the last 3 years, that's been 68, 73, and 64. We haven't gone back farther than that, but typically I think it's between the 60 and 70 as far as cases that we open in the course of a fiscal year. regarding the number of cold cases in Wyoming and asking how the FBI defines a cold case and what those numbers are. For the FBI, we essentially determine a case to be a cold case when we've run out of investigative leads, or we typically take that case and place it in a pending and active status, or we closed status while we maintain the evidence. That allows us, due to the fact, especially in a homicide, if we don't have a statute of limitations, if and when additional information becomes available in the future, it gives us the opportunity to reopen that case and to proceed with the investigation and then prosecution. As far as I'm sorry.
Madam Co-Chair.
Madam Co-Chair, thank you so much for being here. I think we kind of glossed over that. I appreciate your
No worries.
participation. So a few years ago, Wyoming looked at our sexual assault evidence laws, and we passed some requirements that say you can, destroy a rape kit. And so I am kind of curious what the federal policy is for that, because you did talk about a fairly significant number of sexual assaults. What is the policy for retaining that information? And I'm not sure, I guess, if there's a statute of limitation on the federal side. I know some states have that, Wyoming doesn't, but.
Sure. In general, yes, sorry. In general terms, the Justice for All Act is kind of the guiding law that determines how long evidence is going to be retained. That has different standards for biological evidence versus non-biological evidence, and typically is going to take effect with in regards to a sentencing. I don't have the numbers there on that, exactly what that is for those types of cases, but that's kind of our standard by which evidence is going to be retained in a case that has gone through a prosecution. For cases that are cold cases or continue, the evidence can be maintained as a cold case, or as what we're going to be calling a cold case. For the period of time essentially going to be worked out between us and the U.S. Attorney's Office. But if it's a case that we feel needs a better resolution, typically we're able to find a way to maintain evidence as needed.
Thank you. Follow up. Go ahead, Mr. Oak, if you would like to proceed.
Yes, it should be also noted as far as that talking point that the FBI typically does not get involved in homicide investigations outside of an Indian reservation or another federally designated area. We can, to a certain degree, if a state or local agency requests assistance. Typically that would look like a specialized technique or capability, and we do that as we can across the state. We have agents that participate in the DCI Cold Case Task Force, and by talking to my DCI colleagues, it's my understanding they estimate at least 150 unsolved homicides across the state since 1965. Homicide or kidnapping investigation. There are cases that we've had and those that we've not gotten a prosecution on, where it would, as we'd like to see. But typically in my experience, it's not been due to lack of resources. Anytime we've had a case like this and asked for additional resources, we've been able to get those resources. So from our perspective, any case that we have as a homicide case that has not had a successful prosecution has not been due to a lack of resources. Ma'am.
Thank you, Mr. Oakley. So just to follow up with that, meaning that the U.S. Attorney's Office has determined that there's not enough evidence at that point to go forward with the prosecution. Is that accurate?
Yes, essentially, we have the investigation, we follow it, and we do our best to get all the available facts and information, and then that's presented to the United States Attorney's Office, and they have thresholds to whether or not we can actually charge and prosecute an individual. We work closely with them on those, and it's frustrating in our perspective as well if we have a case and sometimes it's just not there and nobody likes it. But until we can get additional statements or cooperation from folks or additional evidence or something like that, sometimes unfortunately that's where it has to be left at until that becomes available. That goes back to our ability to put that in sort of a closed or pending status, with the hopes that eventually in the future additional information might become available and give us an opportunity to pursue a prosecution, if that makes sense.
Right, so putting it pending inactive or something rather than calling it declined and closed, you can keep it
Right. Yes.
open.
Yeah, we can essentially close it, maintaining the evidence because there's no statute of limitations on that. And then it can be reassessed at a later date if we're able to get new information. And lastly, one of our primary strategic goals for our division here this year is to work with the state and locals and the tribes and anyone else trying to get a better understanding of the data as far as the MMIP statistics and people and stuff like that. We want to cast the widest net possible. If a crime's not reported to us or through the BIA or directly to us, there's nothing for us to be able to really do about that. So anytime we do have that, obviously we're going to investigate it to the best of our abilities. But that's one of our strategic objectives for this year, to do what we can to try to get a consolidated list with the widest possible net to identify any cases or individuals that have not, whose cases have not been addressed. That's what I have for the talking points. I'm happy to answer questions.
Abuse of children. I know that there's, you probably don't have it quantified, so this can be an anecdotal. I'm curious if those are, teenagers, older teens, 16-year-olds with, 19-year-olds or something along those lines, or if that's like 8-year-olds and 6-year-olds. Give us a sense of like what that is. What does that 40% mean? Because I'm
sure
that's alarming.
Mr. Oakley?
Yes, ma'am. So by the technical definition, it's going to be anyone that's considered a minor under 18. And I don't have the statistics and actual ages, but I will say we see a pretty wide age range, and it's not just teenagers.
Further questions for Mr. Oakley? And I just wanted to, you mentioned, of course, working with the U.S. Attorney's Office. I just wanted to make sure that there wasn't anybody here that wanted to join Mr. Oakley.
The U.S. Attorney's Office intended to have a representative here, and due to some logistical things that came up last minute, they're unable to.
Great.
But I know they'd be happy to engage at a later date.
Great. Thank you for that. And thank you for being here.
Apologies.
No, you don't have to apologize. Thank you for being here. So like I say, any further questions here? Thank you for that.
Thank you.
So I will take, did you have a question? Go ahead.
Madam Chairwoman.
So, I mean, I just guess I'll throw this out there. Always something that I think that we have to keep on the forefront of our mind as this committee, of course, as representatives of the state.
Madam Chairwoman.
Oh, I think Senator Case wants to vote. Yes, Senator Case.
I apologize. There's a terrible delay on my end, and I know that I'm not being very timely. Sorry.
Senator Case.
I apologize. There's a terrible delay on my end, and I know that I'm not being very timely. Sorry.
It's okay. But what can I go back to that and just do that? Do that? I can do it now. What? So Senator Case, we'll take care of this quickly while we've got you, hopefully. We kept the vote open. Did you and move on, close that vote. Okay, so what I was saying, before I call for public comment is just that I just wanted to say that I really appreciate the FBI being here and the work that the FBI and the U.S. Attorney's Office does, and then them being here at Tribal Relations and interacting with us. This is, of course, a state forum. They certainly don't have to be here, but it just demonstrates the collaboration that does exist with the state and the tribes and the federal agency. So thank you for that, and I appreciate that. So with that, is there any public comment as it relates to the FBI update on the cold cases? Please go ahead and say your name again and give us testimony as it relates to the FBI on cold cases, please.
Again, my name's Nicole Wagon. A Northern Arapaho tribal member. I am for force. I am FUBO. And I just want to clarify what Mr. Jed was stating. Mr. Jed Oakley, correct? That there is no statute of limitations. To make sure there's no statute of limitations for any of the cases that have occurred on the Wind River. I just want to clarify that.
Okay, thank you, Ms. Wagon. We don't like answer questions, and I certainly don't answer questions for Mr. Oakley, although I do think it's accurate to say that there's not a statute of limitations on homicide cases.
Okay, thank you. Moving forward. Thank you guys
Thank
for
you.
your time.
Thank you. Any further public comment as it relates to this? All right, I'll close public comment. We're doing pretty good. We're going to go ahead and take a 13-minute break. And we will be back at 10:40. And we'll be back. And I guess I'd like some discussions maybe from Chairwoman Ellis, if we're ready to go forward. If we want to go ahead and do that and tackle ICWA first, so we can make sure we get that done.
Thank you, Madam Chair. I think we are in a good spot. I see
A 12-minute break, and we will come back and start with ICWA. Thank you.
How are you?
I'm great. Great.
initiatives, but because they're still in arbitration in the court, federal court. But that's been very challenging. If you look back over the years, our tribes have been at the forefront in oil and gas production through the Bureau of Indian Affairs leasing system. But at the end of 2019, the tribes decided not to renew a lease and to operate themselves. So that's what we're doing now. And the reason for that is we're exercising and exerting our sovereignty. And we're trying to look out for the benefit of our people. And so far, things have been going fairly well. Back in the late 80s or late 70s and early 80s, we had an investigation as to the oil being misappropriated or stolen off our reservation. That turned out to be true. James Watt, the Secretary of Interior, appointed a Blue Ribbon Commission, and the result was the 1982 Indian Mineral Leasing Act, which corrected most of that. But that all started here at Wind River. So today, with our initiative as to operating for ourselves, that's new ground. It's not only new ground for our tribes here, but it's new ground for across Indian country. We have a good relationship with the Honorable Mark Gordon. One of the things that we worked with him is the feral horse. The state of Wyoming, we appreciate their contribution to helping out with that problem here on the reservation. It seems to be going fairly well. There's still a lot of horses out there though, so it's not over. The Indian child welfare legislation, we appreciate that. And we see there's some amendments coming in on those, and we'll discuss those as they come up. But signed a letter on Senate Bill 106 in Congress, in which regards funding an officer to help our veterans access benefits and gives information to them. We, as Native people, we have the highest percentage of veterans of any group in the country. Over at the wall here, or whatever it is, we have 1,000 veterans registered there. We're looking at closely at the bills on taxation, and it's a very complicated thing. So we've been struggling with those, but hopefully, we can come to some agreement as to how to go forward. And thank you for putting that on. I don't want to get talk too much here, so I'll allow my counterpart to say something.
Yeah, never too much, Chairman St. Clair. We appreciate you being here. We appreciate your wisdom and your comments. Those are all, as you highlighted, really important issues. And you can't do anything other than just keep working on them. And I hope we're making some progress and that the state can be a good partner to the tribes. So thank you. And go ahead, co-chairwoman.
So dos niaka niente jana. And I just like to welcome you and say hello. Good morning. and it's good to be here. Again, I mirror the same sentiments that Chairman Sinclair also says, together as a new tribal council, we are working on all that stuff. We have Councilman Grossback who is working strongly on the solid waste program. And first off, I guess I would like to offer, I would like to say that Chairman Goggles would like to be here, but currently he is testifying, providing testimony in DC on behalf of Northern Arapaho Tribe. We currently have Councilman Spoonhunter, who is on the national level out there and speaking on the behalf of both the Health and Human Services, and also represents the Rocky Mountain region. So he does a lot of our talk nationally, and he's currently over there working with the National Congress of American Indians at this moment. So we have Councilwoman Hish-Chase, who is currently involved with the MMIP, and so each and every one of us are working somehow in, on the national level, on the state level, and we also like to say thank you to each and every one of you. Myself, I've been involved with the Indian Child Welfare, basically on the home from anything pertaining to DFS and judicial staff, along with Chairman Sinclair here and Chairman Goggles. We all are involved in that. So again, thank you. I just would like to thank each and every one of you, and thank you for having an open mind, open heart when it comes to our people.
You, Chairwoman and Mr. Chairman, thank you all for being here. Thank you for your comments, and we appreciate it. And we're here in service to you. So we look forward to working with you more. So I have some other introductions that I would like to do. Mr. Ivan Posey is here, and he has three, I think, of his students with him. I can go ahead and just introduce, or would you want to come up with your students, Mr. Posey? Completely up to you. You want to bring your students? Are they here, Mr. Posey? He can't hear me. Go ahead and come up.
As Chairman Sinclair said, or mentioned earlier, Zombechu. I'm Ivan Posey, and I'm the Tribal Education Coordinator and Director of Institute of Tribal Learning at Central Army College. I have three of students that are part of our Tribal Wisdom Society. We have one alumni in the crowd here.
Oh, good.
The crowd here, but they're learning, this class for this academic year is learning governance systems, traditional and contemporary systems of tribal governments. We governed ourselves pretty well prior to the system we have now. They'll be introduced to efforts in language and issues that make us tribal. So I'll go ahead and have them introduce themselves, and that's
made it to the halfway mark with the associate's degree in automotive. And being in this meeting is a wide opening mindset about how there still is unsolved cases, and being involved in the tribal law with my professor, Eric Bennett, has really opened my eyes and helped me recognize how this is still a struggle, not only on a reservation level, but the state level as well. And I'm just humble and grateful to be here. Thank you.
well, so to mention, there's 8 in this class. 3 had a loss in their family,
Oh.
and 2 will meet up with us later.
Sorry to hear that, but thank you guys for being here. Go ahead and introduce yourself.
Niyake, my name is Travis Shakespeare Jr. I am Northern Arapaho. I am seeking an associate's degree in wildlife management, and I'm grateful to be here.
Hello, my name is Daniel Gardner, and I'm pursuing my degree in business, and to one day hopefully be in an environment like this. So then that way I can try to make a change in my tribe, my community, and to just lead the youth.
Mr. Gardner, we too look forward to you joining us here in the future. Get your degree and then run for office. So thank you all. Thank you, Mr. Posey, for being here. Thank you, students and tribal members. We appreciate that. I have one more. I just would like to note that Ms. Jackie King, the state director for Senator Lummis's office, spit it out, Lummis's office is here. There she is. I don't think she wants to speak, but hello. And is there anybody else? People are coming in and out that I'm not recognizing. If so, I guess we can do that as the meeting goes on. Okay, so we're going to transfer to the ICWA task force update and be looking at that legislation. So I'm going to defer a little bit here to co-chairman Ellis on how she wants to either run this or testify, because I know you're.
Yeah, thank you, Madam Chair. So I think what I'll do is just give a quick summary of the work that the task force undertook this year, and then go over the bills that are before you. They're pretty short and pretty straightforward, but important nonetheless. During the task force meeting, there are a number of people, but it was an in-person meeting, and wide variety of issues kind of came to light as we started narrowing in on a few of the things we wanted to work on. The first was something that the Department of Family Services brought to our attention. Right now, the Indian Child Welfare Act applies to any case where a parent might lose their parental rights. So for either placement or termination of parental rights, those kind of cases. And as we were working the bill, there's something in the federal act that ICWA does not apply to, and that has to do with delinquency actions. However, our state law that we passed included delinquency actions, so I think it's creating some confusion out there. Department of Family Services works really well with the Wyoming tribes, but when it comes to reaching out to, say, tribes out of state, they're like, why are you calling us on these delinquency matters? So what your first bill, Madam Chair, that we'll get to here in a little bit, has to do with removing coverage of ICWA for delinquency. And then the second issue has to do with safe haven. What happens when you have people who are, given a child, what the process is for, how we handle those children. And so it would clarify that for any particular person who's acting as a safe haven for a child, that they would have a duty to ask whoever's relinquishing that child if they know if the child has tribal affiliation or not. And so that's the quick explanation of that bill. But with that, Madam Chair, I think we did some good work. You have these two bill drafts before you and would ask for your favorable consideration of both.
Thank you for that succinct update, and I know we'll get more into it because there's some, like you say, they might be short, but I think there's some important things that we need to get through, in my opinion, through this session. So we'll dig into that. And so
Madam Co-Chair, maybe we just do some direct, if anyone who wants to talk on both bills or the work of the task force, and then maybe just dive specifically into the bills. We could work, I think, piece by piece. I'm not sure how to kind of lump them together, so.
Co-chairwoman and co-chairwoman, go ahead and state your name and proceed with testimony.
Madam Co-Chair, thank you. So I would like, I guess I would feel.
Who now is if I know the Wyoming Department of Family Services Director Corin Schmidt is here, so I would like to go ahead and is deeply involved with this. So if you would state your name and proceed with testimony and tell us what you've been working on, Ms. Schmidt.
Thank you, Madam Chairman, Madam Co-Chairwoman, and members of the committee. My name is Corin Schmidt. I'm the Director of the Department of Family Services. I think Co-Chairwoman Ellis covered the ICWA task force. I think specific to the bill that's going to talk about delinquents, it's important to recognize a little bit about how the Wyoming Department of Family Services interacts with both tribal departments of family services. So we have the federal law called ICWA, and then we have the state law called ICWA. But then we also have our relationship directly with both tribes through their local DFS offices through contracts. And it's in those contracts then that we pass through state general fund. So the legislature appropriates state general fund, which passes through us to each tribal DFS or to each tribal business council. And it's in those contracts then that we kind of delineate what is the role of Wyoming DFS and then what is the role of the tribal DFS offices. In the counties surrounding the reservation, Fremont County and Hot Springs County, via contract, we have a little bit of a different arrangement that incorporates ICWA, but it goes a little bit further. And in that arrangement, in those contractual relationships with both tribal councils and DFS, those contracts state that the tribes will be responsible for their juvenile services. And this gets a little bit confusing because ICWA does not, as Co-Chairman Ellis mentioned, it does not mention delinquency. However, via our contracts, we do talk about delinquency. And the reason for that is because in those cases where it involves an Indian child per the contract, our relationship with both tribal councils and DFS offices are to go to them first. So these are enrolled members. These may be members that are eligible for enrollment, but the conversation first happens with the local tribal DFS office. Oftentimes they'll take jurisdiction over that case, which is allowed per contract, and then those tribal DFS offices then manage that case. I think removing the delinquency petition from the state ICWA law is to go back to Senator Ellis's point, which is that other tribes in other states do not have the same type of contractual arrangement with Wyoming DFS. So for example, if we're on the eastern part of the state and there's an Indian child from the Pine Ridge Reservation that perhaps engages with local law enforcement and local DFS, if it's a delinquent crime, or if it's any Indian child under the state law, we would then call that tribe and say, do you want to take jurisdiction? And to that point, they're going to say, why would we take jurisdiction? That doesn't apply under federal ICWA law. So it's just to eliminate some confusion and also to go back to some original testimony in the first ICWA task force meeting. Also some concern about from a prosecutorial standpoint that the delinquency is as a result of a crime. It's not as a result of abuse and neglect or a child in need of supervision. So to transfer the jurisdiction of that crime back to a tribe also, I believe, gets a little confusing. So it's really a cleanup, but it's a cleanup that I think will prevent a lot of confusion, which then when that confusion starts, it really comes at the cost of the child, not knowing where the child should be, how to get jurisdiction, and how to move that case forward. So that distinction, I think, is very important as you work the bill. In regard to the safe haven bill, that is also something that's a little outside what we do a lot of times. That is the safe haven law exists so that any parent or any person who believes that they will not be able to take care of their child, and it's a very young child, we're talking infants, that the state won't prosecute that family if they give that child to a specific provider, law enforcement, to fire department, et cetera. So that child can be taken into protective custody. The child will be given to the Department of Family Services, where we'll place that child temporarily in a foster home setting until the time has passed, that then if parents do not come back or family doesn't come back, then that child will be available for adoption. What the safe haven law does, what the bill proposes from the safe haven perspective, is that through adoption or is potentially available for adoption, that we're not concerned at that time about any tribal conversations about jurisdiction from an Indian Child Welfare Act standpoint. So at the very front, when that conversation's happening with a person who's giving the child to law enforcement or the fire department, if that question's asked, then the department later on, as the proceedings start, aren't caught blindsided by a jurisdictional issue, and then that then can help us with making sure that we're proceeding with adoption as quickly as possible. So some of the workings of the department come into both of these bills, and we appreciate very much the partnership with both tribal DFSs, both tribal councils, certainly the task force as a whole, to walk through all of these issues. They can get technical, and they involve policy and law and federal law at that, which makes it a little bit more confusing. So the testimony has been appreciated, and certainly the willingness of the task force to kind of hear some of the comments that we have in regard to how it affects Wyoming DFS. Thank you.
Dr. Schmidt, so questions, we'll keep Director Schmidt around for any further questions as well, but at this point, Senator Barlow.
Madam Chairman, so a question for Director Schmidt. So I understand wanting to have consistency between federal and state ICWA, the approach. My question is, while you do have the authority for delinquency, you have contracts dealing with the delinquency issue for our two tribal nations, do you have actually statutory authority doing that? And my concern is once we have statutory authority and remove it from statute, which is what we'd be doing with this first bill draft, whether we had it before or not, now we're intentionally taking it out, no matter what the context is, whether it's under the ICWA law or it's somewhere else. So is there elsewhere in statute, current statute, where you believe that there is authority to have these interjurisdictional contracts with the tribal nations on delinquencies specific? Thank you, Madam Chairman.
Director Schmidt.
Thank you, Madam Chairwoman and Senator Barlow. That is a really good question. And we've always relied on the agreement, the transactional agreement through the contract to make that decision be filed. Certainly we kind of move around the ICWA conversation through that process, but in terms of juvenile delinquents, it's always been implied through contract, but not specifically stated in law.
Madam Co-Chair.
Yes, go ahead.
I would just like to comment on that also. So as Director Schmidt here has stated, Hot Springs County and Fremont County do work with the tribes and has that contract. And so we have no trouble when it comes to our juveniles. However, the tribes would like to see that be the policy of every county in the state of Wyoming. We currently have a lot of our families that are living in Natrona County, and we don't have the option there. So if there's some way we can make this mandatory so that all we are able to act on behalf of all our children.
You co-chairwoman and Senator Ellis, you had a question or follow-up for Director Schmidt?
No, maybe a response to Senator Barlow. I think, thinking about how this plays out is, if we remove this and repeal, as the bill would suggest that we do, things go back to how they operate. And then that operates until someone says, wait a minute, you can't do that. So I think that it will continue on in practicality. Certainly I could take some notes and we can have more conversations with this task force. We have, I think, a little bit more funding. And so that's something we could probably work on addressing. But, today I wouldn't feel comfortable trying to alter this. This was the work and the recommendation of the task force, but certainly something we can pick up talking about in future task force meetings.
Senator Barlow.
Not wanting to get into, maybe discuss the bill per se. I just present it as a question that when you have something in statute, you take it out. And I think the testimony of our tribal member would indicate that maybe we don't have, it's not being consistently dealt with across the state. That is a state thing when our county attorney's offices are responsible for those certain things. So it may be something we do in another bill or an amendment to this bill in some way, but I think that we should at least have that understanding or discussion about what we don't actually may have, whether we understood it or not, and whether it's actually being fully applied, whether it's understood or not. Sorry, that's too much. My apologies. Thank you.
His force, and then he got tapped for a judgeship. I know, and he's in Natrona County. He's just good knowledge. And then I meant to have the Fremont County juvenile attorney here. And I didn't get that done. But so I guess this is the question. I know he has said this was kind of a big oversight. It was a big, in his opinion, I think, a big misstep by the legislature. And he explained to me better why about the problem that juvenile delinquency being included, what problems it causes. And I know you've tried and you probably succeeded, but can you make another stab at explaining why this is important that we get done, if you believe it is?
Thank you. Okay, so Madam Chairwoman, to think about it in terms of maybe backing up and talking a little bit about the Title 14 statutes, which are what kind of govern a lot of the work that our agency does around child welfare, children in need of supervision, and juvenile delinquents. And each of those actions, they're different actions that are filed by prosecutors who then go to the court, and then they decide if they're going to hear the case. So there's 3 doors in. There's the Child Protection Act, and that is for children who have been alleged to be abused and neglected by their caregivers, their parents, their guardians. There's the child in need of supervision, and that is a child that is incorrigible, unruly. Basically, a lot of our mental health children come into our system through a child in need of supervision petition. Those may be habitual truancy cases. It may be a variety of reasons, but essentially there's something about the behavior of the child and the ability of the family to support that child that comes to the attention of DFS or the court. And then there's the juvenile delinquency petition. And that really is the entrance into the juvenile court system is an illegal act by a juvenile, but then the prosecutor decides whether or not that act and that issue or whatever it is facing that youth and his or her family then merits a little bit more of an intervention that can happen through the Department of Family Services. So a petition will be filed and then the court will say, yes, we're taking jurisdiction. But that delinquency is based on the criminal act of the child. So that's our juvenile court. We look at all of those as kind of family issues. So while in a delinquency petition, there's a criminal act, some of the consideration that's made is, does this family need a little bit more support of what the juvenile court brings? What the juvenile court brings to any one of these three cases is a lot of wraparound support through professionals in the community, DFS, legal support, and then judicial oversight. A lot of what we do is actually comes from federal requirements and law that have been codified into state statute. So it's from that point then that Wyoming has decided, okay, we have a petition, a delinquency petition. We're going to go ahead and hear this in juvenile court, assign the agency, most of the time the Department of Family Services, to provide supervision of that child. So what we can offer at that point is juvenile probation. So we do have a probation. Sometimes it complements what local communities also have in terms of juvenile probation. So they can have county-based probation or municipal-based probation. But then the department also has probation that we then can provide to our juvenile delinquents. What also is available through the Title 14 process in juvenile court that's not available otherwise is the boys' school and the girls' school. So in order to be placed at the boys' school or the girls' school, there has to be a juvenile act or a delinquent act, and that child is in under jurisdiction of the juvenile court, and then the court then can order that child to be placed at the boys' school or the girls' school. So that makes us a little bit different in terms of delinquency that is not otherwise available to other types of juvenile delinquency that is heard in a circuit court or in a municipal court. What is a little bit different, and I think maybe this is getting at hopefully your point, the nebulous, is that Wyoming is somewhat unique in that juvenile delinquency has been incorporated into our thinking around juvenile court and family court. So other people call it family court. Juvenile court for Wyoming isn't exactly family court, but it does have family court type tendencies. And so it's this idea about supporting families, about supporting the youth, that thinking about that home, that providing services to anybody in that home, even though a lot of other states have that particular population, that juvenile delinquency population, involved with their correctional system. And at some point in Wyoming's history, we made a decision that children shouldn't be served, delinquents shouldn't be served in that correctional mindset, that they should be brought into a family services mindset, which is why now the juvenile delinquents at that level are then receiving the same types of services or access to the same types of services that would be available to a family that is working with us because of alleged or substantiated abuse, neglect, or because of a child in need of supervision. So that's what makes this a little bit more awkward when we start to talk to other states and other tribes about delinquency under ICWA. It's just really not, in many, many states, not part of how they look at delinquents. And then to get back to now Judge Tahari's point on the conversation at the task force, really then what happens with a juvenile that is charged an Indian child who commits a delinquent act, and then the services that DFS can provide if under a juvenile delinquency petition, then if that child lives in Wyoming, it doesn't necessarily matter if they're ICWA or not, because we can still provide those services. But if we're stuck, if the agency's stuck in a place, then please let me know if I'm not going where you want me to go. If we're looking at that Delinquency Act and the system's looking at that Delinquency Act under an ICWA framework, then that family approach then has to extend to the family that's out of state. DFS doesn't have jurisdiction to that family. The tribe may take jurisdiction, but it still leaves the criminal act as the basis of the involvement. And what to do with that then is legal issues, jurisdictional issues that are way outside my wheelhouse. So I hope that kind of gets at it. It's states having different approach to their juvenile justice system. That's one part of it. And then it's also really designed, ICWA was really designed around this idea about children staying with their parents, staying with their families, or staying with their culture. Whereas the delinquency is really about the kid.
Important, because we're just digging in. I know you guys have been on a task force and have a deeper understanding, but I think it's important that we try to understand what we're doing here with the delinquency petitions and why it is different in Wyoming. And so therefore why this is necessary. Are you teeing up there, co-councilwoman?
So regarding that, the juvenile delinquency stuff, she's correct when it comes to working with other states. Generally, we're not notified when any of our tribal members or juvenile tribal members are involved with the system. And all the time that I worked with DFS, child protection, juvenile probation, I only got one case from South Dakota, and it was coming out of Rapid City. They had found out that he was a Northern Arapaho tribal member, and so included us in. So that really is an issue there. I don't know how we can fix that. And basically, from the DFS caseworker point of view, with the juvenile delinquency petition, and I'm going to say it again, Hot Springs County and Fremont County, they do contact DFS, Northern Arapaho, Eastern Shoshone DFS, and we do have a lot of input where placement of that child is. However, again, I'm not sure, it's kind of been a while since I've been involved with DFS and done that kind of work. It might have improved, and it might include other counties that I'm not aware of. So.
Chairwoman. Okay, so I see further comment, but before that, are there any questions for Director Schmidt or Representative Penn?
Sure. Director, when you were talking about the girls' homes and boys' homes and things like that, are you, as I understand it, so I assume there's Wyoming State girls' homes and boys' homes, but then I think we also have tribal youth homes.
So I'm going to kind of maybe step back and provide a little bit more of a global view of how placements occur and then apply that to then situations involving tribes, if that's okay. Okay, thank you. So going back to those three petitions of when a child comes into state custody. So a petition is filed, a judge says, yes, this family should be under the jurisdiction of the juvenile court. And then the child will be placed with the department to provide placement. So we then work with what's called a multidisciplinary team. And a multidisciplinary team in all three of those acts is a required set of people, attorneys, DFS. It really depends on the child, but for the most part, the systems that support that family. So they are assigned to the MDT. They're appointed by the MDT or the court to participate. The multidisciplinary team, then the MDT in all three of those cases will work with the families, work with the systems to make a determination about what's the most appropriate placement for that child. So what is available to any one of those children is a series, it's kind of an array of services or an array of placement options. First and foremost, we try very hard to keep the children at home. If there isn't a tremendous safety risk, if we can provide enough wraparound support for that child to stay home, we would like that child to be at home. And the very active removal of children from their family environment is incredibly traumatic. And we want to then understand that from a child's point of view, to be removed from their home and to be placed with strangers can be incredibly hard on them. So we'll first look at, can the family stay safe at home? If the child can't stay safe at home, regardless if they're a delinquent, regardless if they're abused and neglected child or a child in need of supervision, then we're going to look for family, somebody that they know, relatives, kin, etc. So if there's someone within their social support system that's willing then to provide them foster care, and that's what we start to call it now, is foster care, then we'll work with those families or whoever that is to try to get them quickly certified so we know that they're safe, and then the child can be placed there. We will also look at foster care with families who are basically what we think of as traditional foster care. And that if a child needs more support than that, then we start to look at different types of congregate care placement. And in that congregate care placement, we can look at a group home, which is locally operated. The group homes throughout the state are provided by child serving agencies like Fremont County or Fremont. I think I can't remember the specific name of the group home in Fremont County, but I think it's the Fremont County group home. In other parts of the state, we'll have group homes in Laramie, Gillette, Sheridan. They're basically all over. That is an arrangement between the Department of Family Services and those organizations, which are typically nonprofit community-based organizations that are there to serve children in a congregate care setting and provide them with levels of care. In a group home, it's a very, it's room and board, essentially. Kids go to school in their local schools. School isn't provided through the group home. And that if treatment is necessary, then treatment will be provided through through private providers in the community and paid through Medicaid. Going up a step, then if a child needs more than that, if they need a more inclusive treatment episode or treatment dosage, then we'll look at residential treatment centers, or we'll look at what's called qualified residential treatment providers, which are kind of the next step up. It's in those placements then where children are receiving their education on the campus. So an example of a residential treatment center in Wyoming is the Yes House in Gillette or the Cathedral Home in Laramie. They are providing education to that child on campus. They are providing therapeutic services to that child on campus. And that child is there with a series of other children from various places. So they serve children statewide. If a child has a psychiatric need, if there's been a medical diagnosis of needing a psychiatric need, then what's available to that child is what's called a psychiatric residential treatment facility, PRTF. We have 2 PRTFs in our state, St. Joe's and WEI. So that is a medical placement, meaning that this child is Medicaid eligible when they're in the care and custody of the state. That child then has to have some medical diagnosis that says a PRTF level of care is necessary for this child. And then that becomes a Medicaid Plate 14. Then what also becomes available is the Wyoming Boys School and the Wyoming Girls School. So that is then part of the array that MDT can look at as a potential placement option for those youth. So the MDT is going to be discussing with, as there's therapists on that treatment team, there's DFS is on that treatment team, there's a variety of people that will then say, this is what we think is in the best interest of this child. And it's at that point, then they make a recommendation to the juvenile court judge. And then the juvenile court judge then makes the final determination. Does that judge support the MDT recommendations? Then that will be ordered. If the judge doesn't agree with the MDT recommendations, the judge can then order a different placement with something on the record that explains why the MDT recommendation wasn't ordered. And then from there, that child then is, there's a caseworker. That child works with their caseworker, will be working with their parents, will be working with whatever that family unit is to then address whatever the presenting issue was, and then ideally return that child home as soon as we can. Again, trying to think about that family unit. So even though there's a delinquency petition, that child could still go to a group home. That child could still go to an RTC. It really depends on what that child needs per the MDT recommendations, even though what brought that child to the attention of the juvenile court was a crime. So does that help then, Representative, answer your question?
Thank you, Director Schmidt.
Can I just follow up,
It's
please?
important. I'm not done. For us to understand, of course, I mean, as legislators, the entire DFS system, right? And to make decisions. But I just want to bring it back to this, and then I'll let you do your follow-up question. This is a very narrow bill that's in front of us that only deals with removing the delinquency petition as it relates to Wyoming law and how probably we overstepped by including it because of Wyoming law in this ICWA bill. So I just want to we gave ourselves some extra time, but we don't, we still have to be done by noon. And we have to go through these two bills. So with that, Representative Penn.
Thank you, Madam Co-Chair. So are there group homes that are just for the ICWA kids, the tribal kids?
And I mean, they're any children, but I'll let certainly.
Thank you. Madam Co-Chair. Representative.
Okay, hold on.
Sorry.
Before people come up, we call people up to testify, and so I'll let you go ahead again, Co-Chairwoman, if you've got something on the tribal group homes.
Thank you. Thank you, Madam Co-Chair, Representative Penn. We do currently have a group home at Northern Arapahoe, and it's located there in the vicinity of Riverton. Eastern Shoshone currently has one also. I'm not sure if there's any of their representatives, the tribal members here, who would speak on that. I would just also like to add that our DFS programs have other options also, not entirely sending them off to the state school, Wyoming Boys State School. We also have the ability to do intensive supervision for the juveniles, which means increased daily, sometimes twice daily contact with that juvenile in their homes. We also, I'm not sure if that is available yet, but we also were able to use like the ankle monitor for the juvenile, so they would be able to continue to be in the community and with their homes. I hope that answered that. Thank you.
Any other question? Do you want the co-chairwoman to stay? Will you stay? Ms. returns to Ward. Representative Chestik.
Madam Chairman, I have a question for Director Schmidt. When I first saw this bill, the explanation made perfect sense to me that we take delinquency petition out. But some of the things you said made me rethink that a little bit. I think we're still okay, but as I understand the purpose of ICWA, the whole policy behind ICWA is to make sure that when a juvenile or a child needs, for whatever reason, to be relocated from their original family, that we try and preserve the culture by preferring placement with another member of that culture. And that's why delinquency petition is a whole different concept. So I get that. But some of that placement where that child needs to either go back to their original family or somewhere else. And so that made me think, do we need to keep delinquency petition in for those situations at the end of a placement? But then I saw maybe, and this is my question to you, when the delinquent comes out of the placement and needs to be relocated back into the family or maybe not the family, would that student or that person then fall under the allegation of a need for supervision? Would that capture that person, or do we still need to have some language here that would allow or that would require the juvenile court to put the student back into a placement within the culture?
And either one of you, Director Schmidt.
Okay, thank you, Madam Chairwoman. Representative Chestik, I think there's kind of a defining difference between a child in need of supervision and a juvenile delinquent, and that's the crime. So that delinquent has committed a crime, whereas a child in need of supervision has not. So when we think about then our system, in any juvenile court petition, we're going to provide the same type of array of services, which is really going to be based on the needs of the child. So if a child is a delinquent and still needs continuing services after they've returned home, we'll continue to provide those services. If the case is still open, we will provide it. I think maybe I probably did this, and so I want to back up. What really is the difference about this particular bill is as it applies to ICWA. It doesn't change anything we do for a child who has been alleged to be or substantiated to be a delinquent and end up in the care and custody of the state. This does not change this. What this bill does is say, do we as a state have to reach out to the tribes, other tribes, to tell them that we have a child who's a delinquent, and do they want to take jurisdiction over that case, which then we move the jurisdiction of that case from district court to whatever tribal court is within their system. That's what makes this really hard, is that tribal courts in other states don't recognize to delinquency. For our state, though, we would be one of the few, I don't know if there's any other states that apply ICWA to their delinquencies. So it's less about, it's more about keeping federal ICWA intact and conforming state law to federal law, because it is a federal law and the system knows how to work interagency and interstate under federal ICWA. for Wyoming to come in and say, oh, no, for purposes of kids in Wyoming, we're going to apply ICWA. That's going to be hard for other tribes, states to recognize. While that's a procedural issue, I get it. But what that does, though, is it puts that child in limbo. And that's the concern that we would have, is that that child, while we're working through all of this bureaucratic stuff about how to switch jurisdiction, that child is not going to be getting much as we try to figure out what to do. So that would be maybe the casework approach to a reason why this would be important, in addition to the legal approach that at the end of the day, it was still a crime.
Thank you, Director Schmidt. I think that clears some things up. Further questions? All right, thank you. And I know that, yes, I know that Councilwoman Harjo was popping up earlier to testify. And hello and welcome as well. So if you, yes, if you would like to introduce yourself and proceed with testimony.
Councilwoman Kim Whiteman Harjo from Northern Arapaho Tribe. So some of the questions that you had were instances that we ran into with other tribes living here. So not only do the Shoshone Arapaho tribes live here, we have other tribes living here also with Indian children. What we had seen in some of our systems is exactly that. This child is enrolled in South Dakota. This child isn't enrolled here. Some of the things that we have run into and what we don't like is other states where our children are residing, they do not, we don't know if they're in the juvenile delinquent system. We don't know if they've been taken out of a home and need to be placed in another home. That live in Casper, they live in Cheyenne, they live in Gillette. We have a lot of people that have moved to Rock Springs and currently in Evanston. So we do have a lot of tribal members that don't live on the Wind River. And that's our concern, is our children, if they do get into trouble or they do need that help, they need to be placed in a safe home environment. The whole reason for the Indian Child Welfare Act is just that, to make sure we know where each child is and to make sure that they're safe. Within ourselves, we have our own systems in place to take care of our children, whether it be a group home, foster home, those kinds of placements. So we do those here. And I just wanted to bring that forward so you do know that we do have that in place, as well as looking towards the state group homes also. And we do have children in the group home also. But working through this ECWA bill, I really want to thank a lot of you in the legislature for working with us, talking with us, asking those questions. We really appreciate it. So I just wanted to mention that. Ho. Thank you.
Woman Harjo, any questions for her? Thank you. Thank you for being here. Thank you for testifying. Further public comment. Mr. Winley. Yeah.
Chairwoman Oakley, I'll be short and sweet. We of course defer to the task force work and Director Schmidt and the council, various council's comments. As the bills go right now, I think from the governor's office perspective, we're comfortable and defer to the good work done by the task force.
Further public comment, and Chairman St. Clair would like to come up. And then while you're coming up, Chairman, I guess I'd like to maybe, if I close public comment, are we doing it are we on both bills?
Madam Chair, I think it'd be appropriate to ask for any more public comment on this bill, then close it. We'll work this bill and then we'll start to the next one. Yeah.
Thank you for that, Co-Chairman Ellis. Welcome again, Chairman St. Clair. Go ahead.
Okay, Chairwoman Ellis, co-chair, members of the committee. I just want to state the position of the Shoshone tribe regarding some of these bills. First of all, we do agree with the safe haven. That needs in our tribe was placement of children when neglect is first detected, especially if it's a law enforcement issue where someone, for example, is caught with their children in a situation of DUI, and it's hard to sometimes even for DFS to find a placement at that time. Previously, many times a policeman would have to drive around with a child in his car because there was no placement. So that alleviates that problem. So now getting back to the Indian child welfare delinquency situation, working in the court system for the years that I have worked there, I know that the system in Wyoming is unique from other states, with the minor need of care, the child ordinance supervision, and the delinquency. We, in our court system, do deal with the delinquency petitions similar to what the state does. The Boys and Girls School recognizes our commitments as long as it meets the requirements, which is the child has to have been involved with a crime. So those go through our system. But the intent of the Indian child welfare is about removing parental rights and adoption. And when that occurs, say a child is involved in a crime in Cheyenne or Casper under the state system, we would like to see something where if it goes in the direction of adoption, and sometimes they do, that somehow we would be notified and involved. So within the Fremont County contract, I think that's covered, but it's not covered outside the state. So I'm not saying that we need to take all the juvenile delinquency cases into the tribal court, but only when that case out in the state starts to go in the direction of termination of parental rights and adoption of the child. That's where we feel, an agreement similar to what we have in Fremont County. And I think that's what co-chairman Karen Returns to War had brought up is we need to have some involvement where it goes in that direction. If it's a juvenile case. But if it doesn't, if it just there's no change of custody, it just stays with the parents or relatives, then I think it could go through the state system just the way it is. So I'll just throw that out and let you come up with a solution.
Thank you, Chairman St. Clair. I always appreciate your legal mind and prowess. And I think you just nailed it. I mean, in my mind, as you said, co-chairwoman Returns to War said it and you said it. And I think, so what you're looking for, it seems to me, is perhaps that we can pursue maybe we can pursue this as a state, but expanding the MOU to other counties. I think Natrona County, it was mentioned. And I think that's good. And we have these discussions and it brings that up. I think what else just listening to you that made me realize that that I think reiterates the need for this, which is we went too broad and crossed lines and it muddles things up. So ICWA, like you said, about parental rights and adoption. And now we've included this, adjudicated delinquent, which is like criminal acts, and it confuses it and makes it messy. I think we need to keep them succinct. So to me, I see maybe a two-part. It's not what's in front of us today, but I think we pass this. And then with what I've heard from you, I think perhaps we look through this committee, we can start looking at if an MOU would be, would be important with those other counties within Wyoming. So I appreciate your testimony. You guys have made it, I think, clearer for me. So thank you. Questions for Chairman St. Clair? Thank you.
Okay, you're welcome.
Further comments or anything, and now I'm going to just limit it to before I close comment, if there's any further comment as it specifically relates to the ICWA delinquency amendment. Okay, go ahead, sir. Come on up.
This doesn't specifically relate to the ICWA delinquency case that we're talking about, but it's something very important that I think we should
comment on other issues. So if you said it's not about this bill, what is it that you what issue are you wanting to discuss with the committee?
This falls in line. My name is Larry McAdams, and this falls in line with a lot of stuff that you've already been talking about, especially with Corin Smith in the DFS department, States Department, and the Tribal State Department. And I feel that this issue here that we got to talk about is directly in line with concerns that have been brought up and issues that have been brought up. And I'd like to have Arnella Oldman begin the questions, if that's okay with everybody, because the case originated with her family and as an ICWA case.
Okay, we'll certainly hear from you. Thank you, Mr. McAdams. And then I think I will have you introduce yourself. I think I heard Ms. Oldman. But I would like to say, one, we're on a limited time, and two, we are on comment about the ICWA bill as it relates to the delinquency amendment. So go ahead with that if you'll introduce yourself.
My name is Arnella Oldman, and I am an Eastern Shoshone tribal member. I have a grandbaby that was under the ICWA program, was under ICWA at one time. And then for some reason, this baby was taken out of our family and taken to a group home and not notifying us as family for placement. And we talk about our children being placed with family all the time, and family being the most important people that these kids are supposed to be placed in. And that did not happen within our family. And I just wanted to make that clear and make that known, that there was no one ever contacted our family or anything, but the placement was just placed under the direction of the Eastern Shoshone DFS director without notifying our family. I mean, she was, I'm just letting you know, I guess, that's what happened. And I'm kind of concerned because we need to know where our kids are. And this is a little baby that was taken from us. And, we need to know too, to where she's at. And they have not even notified us as family. Family has called. We've had no return calls.
Okay.
And so I just want to find out what the real protocol is, what procedures that we should do, what, you know, in case of situations like this. I know I'm not the only one, but I will stand up and say there are several, and, you know, we need to know where our children are being placed.
Thank you, Ms. Oldman. That's a little out of the purview of this
But I'm
committee,
just-
but the
yeah.
good thing is that I bet we can have some conversations, maybe. I know there's some people in the room that could visit with you here today, so
Okay.
hopefully.
Good. Okay, thank you.
If I might intervene and add a little bit more to that.
Yes, Mr. McAdams.
There is more than one case that we are concerned about, and I've been getting calls from tribal members concerning our Department of Family Services, our tribal Shoshone, the Eastern Shoshone Tribal Department of Family Services, ESDFS. I do not know why the director is making these decisions to remove these children from the families and not place them or contact any other family members that can take care of these children. The case that Arnella is talking about now, the director removed that child from the maternal aunt and the paternal grandfather's home and place that child in the group home, the local group home that we just established not too long ago. There are at least 5 or 6 other direct family members who are all capable and well-known on the Eastern Shoshone part here that was capable of taking care of this child, this little baby. The director never contacted any member of those families to see if they would take it. She just put that child into the group home. And as Arnella mentioned, and Corin mentioned also, that's very traumatic, removing a child from his home and placing it in a placement where there is no family connection at all. Whether it's monetary, I don't know. But the families of this case and other cases have taken these case issues and concerns to the Business Council. The Business Council refers each and every case to our Human Resource Department, or HR. That person doesn't know DFS procedure, caring for children in the confidentiality of cases. She's there just for human resource purpose. So there's a big problem here. Can't get nothing done. We contact the state DFS, and I was told that the aunt contacted the state DFS department down there and was told that they could not intervene or help that family in any way because of our sovereignty.
So, thank you, Mr. McAdams and Ms. Oldman, and I will just say I'm extremely interested in child welfare. I'm very sympathetic to what you're talking about, but we also have to be very cautious here as what this group is here to do. We're state legislators. We certainly don't have oversight of tribal affairs. We don't have, and you mentioned confidentiality, Mr. McAdams. I think it would be inappropriate for us to start in any way using this platform to discuss or insert ourselves into these individual cases. So I appreciate you being here with us today at Tribal Relations at the Select Committee for the Wyoming Legislature. And I wish you luck on this. Hopefully you can talk to some representatives here and from those agencies and get those answers. But I think at this point, there's nothing that this committee can do about what you're telling us. So I appreciate it, and we're gonna move on.
Okay, I appreciate that. I understand all of that, but we just needed to make it known to this committee that there is concerns and problems within our Department of Family Services here.
Right. Thank you
We'll-
both.
We'll talk with Corin.
Okay. Thank you both. Okay. I think we are done. Seeing no hands, I'm going to close public comment as it relates to this bill. And committee, what is your pleasure? The bill has been moved by Senator Barlow and seconded by Co-Chairwoman Ellis. And are there any discussion or amendments on the bill? And I'm going to do this at everybody's peril. Senator Case, are you with us? He's not. Okay. Yes, Representative Chestek.
you, Madam Chairman. I have no amendments. I'm in favor of the bill. I do think that I just want to make a comment that and I asked the question about whether or not when the case moves towards adoption, should we cover that somehow? I think it's already covered because if the delinquency case turns into an adoption case, then the first on line 12 adoption, it's now an adoption case and this bill does kick in. So I think we're covered there. And I also think allegation of a need for supervision also covers some of these transitional cases. So I'm okay with the language as it is, and I'm in favor of the bill.
Chestek, further comment, further amendments? Okay, question having been called. Roll call vote.
Madam Chair, this is a roll call vote for 24 LSO 0167 Indian Child Welfare Act Delinquency Amendments. Senator Barlow, Senator Case, Representative Chestek, Representative Penn, Co-Chairwoman Ellis, Co-Chairwoman Oakley. Madam Chair, there are 5 ayes and 1 excused.
Thank you. Okay, so there has been quite a bit of discussion. We've kind of intermingled them. But so we'll move on to if there's any further comment regarding the Safe Haven Amendment. I know Chairman St. Clair spoke in favor of it. Did you have anything further? Okay. Going once, going twice. Okay, public comment is closed as to that committee. What is your pleasure? Second. The bill having been moved by Senator Barlow, seconded by Co-Chairwoman Ellis. Committee, any discussion or amendments? Co-Chairwoman Ellis.
Madam Co-Chairman, I would move, I think on page 2, line 10. LSO had brought this. I'm looking at Lily. It's just a small grammatical change. I think it was expresses to express. So it would be the motion as on line 10, change the word expresses to express. And I think that's a grammatical change, but might as well catch it now.
So that's been moved by Co-Chairwoman Ellis and seconded by Senator Barlow. I need to look at a person relinquishing expresses in it.
Take your time. Take your time, Madam Co-Chair. I reread it several times. Yeah. It's, I think, right, but I hear it.
Looked at it. Is there any discussion on the amendment? All those in favor say aye.
Aye.
Aye. Maybe we didn't give enough time. So that amendment passes. Any further amendments or discussion on this bill? Senator Barlow.
Chairman, so when I look at statutory construction, mays and shalls are a big deal. And in this, and I'm just going to go to line 5, page 2 of the bill. We're going from may, which was a big, long, and ugly sentence before, and we've split up the sentences. But this now requires the Safe Haven provider to inquire about this tribal affiliation. And all I want to make sure, and I'm fine with that, all I want to make sure is if they don't inquire, does that change the legal process anywhere else? And I don't know, I'm not saying we have to answer that now. I just want to be clear that if for some reason that is not done by that volunteer person who receives this child, are they somehow at some legal, or they at some peril for not performing their duty properly, or is the child in some way in peril for not in the process because it wasn't done on their behalf? So like I said, I just throw it out there as something to think about. I'm going to support the bill. I'm not suggesting a comment. Is maybe something for our staff to think about between now, if this bill moves forward, and the session. But I just throw it out there as may to shall places a burden, a legal burden. Does it place a legal burden on that, and how might that affect the process? Thank you, Madam Chairman.
Thank you, Senator Barlow. Just for comment, it doesn't clear up anything, but I would say that certainly it does. I mean, that's exactly what that shall word does, right? Is creates that. It's a mandate. There's no doubt about that. But that's a good question. I don't know. I'm looking over at our staff. I don't think it did. Mrs. Sharp.
Madam Co-Chair, I know we're running low on time, but I didn't know if Director Schmidt, we didn't dive into this one quite as thoroughly. We could do that, but I think this was something we did discuss during the task force meeting, and there's a reason.
You shall. And I kind of saw shaking the head. Do you feel like you want to weigh in at this point, Director Schmidt, or not? No. Okay. So I guess we'll leave that for as food for thought, and no amendment, seeing no amendment. We call the roll.
Madam Chair, this is a roll call vote for 24 LSO 0281 Indian Child Welfare Act Safe Haven Amendments as amended. Senator Barlow. Senator Case, excused. Representative Chestick. Aye. Representative Penn. Co-Chairwoman Ellis. Co-Chairwoman Oakley.
Aye.
Madam Chair, there are 5 aye and 1 excuse.
Bill is adopted. And with that, I think we are done for the day. The committee's going to go do some tours of K through 12 schools, and we will reconvene tomorrow at 8:30 in the morning.